Good morning and welcome to the Massachusetts Appeals Court on this beautiful Monday, November 6th. Sorry for the false alarm back there. We had
That was my fault. Taking full responsibility.
just a little issue. I know that many of you are experienced here, but I'll run through the rules. I should also introduce my panel, though. We've got, I'm Judge Joseph Ditkoff. To my right is Judge John Englander. To my left, Judge Maureen Walsh. We have a clock there. Each side will get 15 minutes. It'll show green for most of the argument. When it gets down to 90 seconds, it'll start showing yellow. When it runs out of time, it will turn red and start counting up. Don't be fooled to think that that's still time remaining. When it turns red, you can finish your sentence. But other than that, I'd ask you to stop unless you're answering questions from the panel, in which case please finish your answer completely. We have, I promise you, we have read the briefs. We have gone through the appendix as much as we thought we needed to. So there's no reason to give us the background. You can jump right into your argument. And as always in the Massachusetts Appeals Court, there will be no rebuttal. All that having been said, I will call the first case today, 23P43, Wilmington Trust National Bank versus MCSHARRY. Counselor, whenever you're ready.
Thank you, Your Honors. Good morning. Attorney Luke McCardle on behalf of the appellant, Michael MCSHARRY. You may please the court. We're here today on a post-foreclosure summary process case that went to settlement. There was an agreement for judgment, a global settlement regarding 3 different cases that were consolidated, and there was an agreement for judgment that was filed with the court on December 14th, 2020, which was subject and an exhibit to a larger settlement agreement, which I'm sure you guys have reviewed. The issue that happened following the filing was that the court didn't enter the agreement for judgment until maybe 2 years later, but they did enter it nunc-pro-tunc back to the actual date when we submitted it. So it caused a little bit of confusion as far as has the case gone to judgment? Was it an interlocutory appeal? Was it an appeal that goes immediately to this panel? So my brother brought this defense up in his brief, and I hadn't addressed it in my brief. So I wanted to address that.
Let me just stop on it for a moment because there's a key factual issue. You say that it was signed by the judge at the time?
It was signed by the judge at the time, but it was never entered.
It wasn't entered, but the judge, how do we know the judge signed it at the time?
I don't know. I actually don't know if the judge did sign off on it at the time. I guess I could defer to my brother if he knew that question when he's up here, but I do know that it was entered later, nunc-pro-tunc, to December 16th, 2020. So essentially, it was entered on that date. Whether it was signed at the time or not, I'm not sure.
Okay.
If I have the answer to that, or what the relevance of it is to the.
Well, the relevance of it is whether or not this is an interlocutory appeal or whether it's an appeal from a post-judgment order. That's the relevance.
Yep. No, I understand that. But also addressing that, even if it was interlocutory, which I don't agree that it is an interlocutory. I think it is a post-judgment appeal. Even if it were interlocutory, an interlocutory appeal isn't mandatory. You can still wait till after judgment to appeal that. You don't have to go through the single justice petition. You can always wait till judgment is entered and then appeal that. It's still an appealable order. It's good practice to preserve it by notifying the court of your intention to appeal it, but you don't have to take the single justice route.
That's absolutely true, but we do have to have a final judgment at some point. And if the 12/15/2020 agreement isn't a final judgment, I'm not sure there is one. Is there something else that could serve as a final judgment if that isn't one?
No, that is the final.
But it was entered 2 years later, is what you say, right?
It was entered, correct? Nunc-pro-tunc back to the
But it was entered after the notice of appeal had been. Okay.
And just for the record, I'm looking at the Record Appendix 127, and that's the order dated January 5th, 2022, signed by the judge.
Okay.
That's what I see. If there's something else bears another signature of the judge, I'd love to know, but that's the one that I see is the order dated January 5th of 2022.
So if you go to the docket entry, which is one of the first in the appendix, the entry of the entire docket of the case, there's an entry on April 13th, 2022. That's the nunc-pro-tunc entry of the agreement for judgment. So it's April 13th, 2022. That docket entry is the order for the agreement for judgment being entered nunc-pro-tunc back to December 16th, 2020.
Right, but as far as the original order and having a signature on that date,
Oh, the original signature on it.
right,
No, the date, no, there's an agreement, the agreement for judgment itself
right.
has a signature that purports to be from a judge dated 12/15/2020.
Okay, correct. So it was signed. I think it was more of a procedural error regarding it just not being entered. It was signed and agreed. So there was after the agreement for judgment was entered, there was a bunch of post-judgment motion practice to try to kind of unwind what was a confusing state of the trial court, and there was several different judges involved, so it became quite confusing, and they wanted to send it back to the judge who presided over the motion, and then it became another judge, and it became quite, the twists and turns, quite a headache, to say the least, before actually getting here. So I think after briefing, because we went through extensive briefs regarding the applicability of Chapter 231, Section 118, or if it was immediately appealable. And I think that the court made the proper determination in the end regarding it being immediately appealable, and that's why we're here now.
There's some other issues to talk about here. Maybe if it's okay with my colleagues, we can move on, because I was also struck, until I read the Duff case, by the awkwardness of this posture that you're in, because you briefed this as if you have a breach of contract claim, right?
Right.
And you talk about determining breach and determining what your appropriate damages would be,
Correct.
right? But you don't have a breach of contract claim. You never filed one. What you have is a motion, and Duff suggests that that's enough, right?
Correct.
But what do you want, what do you think the judge should have done with your motion?
Well, the judge should have determined that it was an enforceable contract. I don't
Okay,
think,
so let's go past that.
sure. And
Then what?
and enforced it, specific performance. It was the first request. If specific performance wasn't available, which I think it was in that scenario, just move it out the 60 days that was contemplated by the signing of the purchase and sale agreement and the closing.
Well, first, wouldn't the judge have to determine there was breach?
Yeah, I think that
And
was.
your claim of breach is what?
The claim of breach is there's a material term of the contract regarding the
3
date-
days?
The days for performance, which were all, time is of the essence, which you hold your parties accountable to the deadlines within the contract, and there's a time of the essence clause.
Do you have to show in your claim for breach that you were able to perform?
Yes, and we did that.
How did you do that?
The case law shows that if you produce a loan commitment that is akin to establishing ready, able, and willing, and they did that. That's part of the.
But the loan commitment was for less than the full amount.
Oh, it was for $575,000 on a $600,000 purchase. No one gives a loan commitment for 100% value, so that's very standard.
Right, but you needed the other 25 grand. Did you prove that? Did you prove up? And what I'm trying to get at is, you actually ask us to like reverse this and enter judgment in your favor,
Right.
and I'm struggling with the notion as to how that we could do that, given the facts that are in the record, even if we agree with you.
Right, I agree. I asked also to potentially alternatively allow this to go to trial because there seemed to be some disputed facts. The judge even created a disputed fact over facts that weren't in dispute, but nevertheless, I think there's enough in here to show that there was a breach, and there's enough in here to show that my client was ready, willing, and able. And if there's a repudiation or a renouncement, my client doesn't necessarily even have to show that he
I
was
understand
ready,
that
willing,
point
and able.
too. I understand that point. Let me ask you this. Is your client still on the property?
Yes.
So specific performance is actually something that could be ordered.
Yep, and they're paying $4,500 a month during the pendency of this, and that's like 3 times more than what the mortgage was.
So when you say specific performance, what specifically is the specific performance?
Just the material terms, the $600,000 net purchase price, but for the closing costs that were agreed to be paid for by the seller.
Do we know that the third-party buyer is still available?
That's the only, it's a large issue, because you can't have somebody sit around and you know, be ready and willing to enter into this agreement, and obviously the economy and real estate market has drastically changed. So that the specific performance has become a bit of an issue at this point because I don't
Right, so
know.
I'm trying to figure out, if you prevail, you show that you complied with the agreement, they breached it, then what does the judge order?
At this point, I would be inclined to seek damages in the amount of the fair market value of the property less what the purchase price was, the equity that he would have gained in the property at this point. I think my client would be agreeable to that at this point. I
But
know
your client wouldn't have gained any equity, the third-party purchaser would have.
no, but it was an arrangement through a nonprofit organization where he was getting an opportunity to regain owner and title to the property. So it was essentially an opportunity for him to get back and maintain the home, or utilize it in some way with the third party to unload it and share in the profit to some degree. So either there was equity above that price, and that's the only reason the
Right,
nonprofit.
but who's entitled to the equity? That's the question that Judge Ditkoff's asking.
Well, my client's entitled to the equity.
Your client doesn't, even under this agreement, your client would not be the owner of the home.
Correct. As far as the title, would be temporary.
What the contract contemplated was not that your client would own the home.
Right, but-
Under the contract that you're trying to enforce.
Sure.
Right?
Sure, but that's the benefit of the bargain is the bargain that he's getting for this property, and his agreement with the third party could be just that. They sell the property after they close on this, and the equity becomes theirs.
So-
Whatever his agreement is with that third party is you know, I guess outside of the bounds of this agreement and what we have in front of us.
If we were unable to agree, let's just say that specific performance should be ordered. What's your remedy?
My remedy is getting a BPO or an appraisal of the property. I guess we'd have to stem it back to the time of when it was supposed to close in March of 2020 and try to get a fair market value of the property at that moment, and then take the $600,000 and say what was the value of this settlement to this person and come up with a figure.
What are you asking the appeals court to do?
Well, I think the appeals court would have to remand it back for an evidentiary hearing on that issue, on the value.
Thank you.
That's interesting.
So
It's an odd.
let me try this. I mean, I'm looking at the agreement, and it says that if the defendants fulfill their obligations, then what's supposed to happen is the execution's null and void, and both parties have to file a joint motion to vacate the judgment and joint dismissal with prejudice.
Right.
Why wouldn't that be the remedy?
Well, that's also one of the remedies. They all of these, the defendants in these three different cases, they all now have an eviction on the record. Part of it, switching it to a dismissal with prejudice, is obviously to remove that from their, their future ability to rent is affected by that. And some of them aren't really even involved in it. They were just children that lived there at some point in the past that no longer have any possessory rights. So just unwinding that whole situation is also something I asked for within the brief, is to enter a dismissal with prejudice as to all of those occupants and the defendants that were identified in those three consolidated cases.
Are all, I mean, I'm outside the record, but are all 5 of these still residents at this property?
No, they've been gone for multiple years. They're grown children with their own houses. There was one living in the in-law apartment at some point, but that was 2 years prior to the litigation. I think it was over precaution for just to make sure they had full possession of the property. But yeah, otherwise, I think that the facts are clear. The case law is pretty clear on the binding nature of this contract. Highly contentious, negotiated contract that was put together by relatively experienced and, well-practiced attorneys in this area of the law. My brother and I have, gone into these cases together. We've settled and gone, had situations like this. I've seen these boilerplate agreements many times, and to suggest that it's wouldn't be legally binding, feels a little absurd. I know it's an argument that my brother has to make, but I think what removes this immediately, even from looking at a standard offer to purchase as a binding agreement. There's terms within this that are full releases of the parties. You file an agreement for judgment that dismisses all of the claims. There's language in here that says you're acknowledging that this is a legally binding agreement. It takes it outside of it's similar to the McCarthy-Tobin case. Basically, is once they determined it was offer to purchase the material terms, what increased it was the fact that within their offer to purchase, it says this is a legally binding document, and that's I think it's referenced more than once within the settlement agreement. But also reporting the settlement to the open court and entering an agreement for a judgment. The intention of the parties is clear. They were intended to be bound by this agreement, and I think any argument otherwise is a difficult one to try to make. But
Can we go back? I'm sorry, but can we just go back to the? Let's make some assumptions. Let's assume that we agree it's a binding agreement. You then have your clients then have a claim for breach under the agreement. If they succeed in their claim for breach under the agreement, they might have a remedy for specific performance which would obligate the defendant to sell the property to someone else who may or may not be willing to buy.
The agreement was for my client to effectuate the purchase at $600,000, to effectuate it in any manner possible.
By a third party.
By a third party, but if you'll see in the transcript.
Oh, that's true.
You'll see in the transcript, my brother said it doesn't matter who comes up with the $600,000. It was McSherry's, it was my client's duty to come up with it, no matter if he used somebody or if, a bank was willing to lend to him, but he's in foreclosure, so he's not getting any, a loan. So that's the.
Okay, thank you. That was helpful.
Okay, all right.
All right,
Thank you so much.
Thank you very much. We'll hear from the bank now. Just a sec. Madam Timekeeper? All right.
Good morning, Your Honors. May it please the Court, Kevin Polanski on behalf of the appellee, Wilmington Trust. The first issue I want to address is the timeliness of this appeal. As just asked during my brother's argument, there was a judgment prior in this action that was entered for possession against the defendants. That was a judgment that ultimately a notice of appeal was filed, and that was entered in February of 2020. Because of the ongoing negotiations and the hope for peace finally with respect to these parties.
Was that a final judgment, though? It didn't resolve the counterclaims.
The counterclaims were separated and moved over into a separate civil action, so it was final. And there was a notice of appeal that was filed with respect to that.
Help me with that. What actually happened to the counterclaims?
The counterclaims were separated, they were severed, and then a separate action.
An order that severs the counterclaims into a separate action.
That's right.
That was done by agreement?
That was done by the judge. The judge entered possession on the foreclosure or eviction summary process claim. That was an affirmative claim filed by my client. Entered judgment on that claim and said your counterclaims are severed and you can pursue those in a separate civil action. So judgment did enter, and I believe the date was February 20th, 2020, and a notice of appeal was filed. After that point, the parties began negotiating a resolution of both that judgment and other ancillary matters, including the appellant's kids' summary process actions. That was negotiated in December, and ultimately this motion to enforce transpired because the parties were unable to come to an agreement to purchase the property.
But you've skipped the agreement for judgment dated
February 14, 2020. That was signed by the judge February 15th, 2020.
December
December 14th, 2020.
That's right.
agreement for judgment, signed by the
Agreement for
judge.
judgment, yep, was filed by the parties, all the parties in the 3 separate summary process actions,
Signed by the judge?
signed by the judge December 15th, 2020.
Why isn't that a final judgment?
That would be a final judgment.
Okay,
Yes.
so that's also a final judgment.
And it was appealed, timely appealed from?
It was not. Our position is that it was not timely appealed from. There was no notice of appeal filed within 10 days.
Oh, I'm sorry, but this appeal is from the judge's order on the subsequent motion to enforce a settlement agreement, which
Right.
is a post-judgment motion.
It is a post-judgment
So
motion.
there's a timely appeal from a post-judgment motion.
Well, I guess I read Rule 4 of the Mass Appeals Court a little bit differently in the sense that it says, unless otherwise specified by statute. Here, 231, Section 18 would be an interlocutory order.
Only interlocutory if it's before final judgment. That's my understanding. Having spent the last month doing single justice, it's pretty, it's pretty recent, too. What am I wrong about?
Well, I think that if that were the case, you could, the appellants could have filed a motion to enforce a settlement agreement at any point in a case that's already been adjudicated. Judgment has entered. There's no ability to timely enter.
Yeah, that was what I was talking to your brother about.
Right, and so
But that's not what happened here. They didn't file it at any time. They filed it contemporaneously with the agreement for judgment.
they filed what?
I'm sorry, they filed the motion, what, like a month or a month and a half after the agreement for judgment?
They filed it 3 months later, yes.
All right.
And that was decided March 15th. Unfortunately, it wasn't docketed. COVID was going on. It wasn't docketed until October 15th. And then a notice of appeal was filed on November 1st, 2020.
Within 30 days of the date the judge denied the motion.
Right, that it was docketed, right.
And we have this Duff case, which has this sort of what strikes me as an odd procedure, but anyway, that seems to be what our courts say, which is he doesn't have to file a separate complaint. We'll treat a motion to enforce an agreement for judgment as if it is a claim for breach of contract.
Yes, Your Honor. But it
Okay.
still must be timely appealed. And our position is they would have had to have gone through the single justice process for adjudication of their appellate rights. They didn't do that. They could have filed a separate action and then sought resolution and appealed that judgment, whatever way it went. Those are the two actions I believe they could have taken. Because this is post-judgment, in a housing court matter, you have to appeal a judgment within 10 days, and that was not done here. It was 15 days later that they appealed.
15 days after what?
I'm sorry.
15 days after what?
October 15th was the date that the order on the motion to enforce settlement was docketed. It was decided March 15th, not docketed till October 15th. They didn't appeal until 15
No, you
days.
said in a housing court matter. The 10-day rule has to do with a summary process judgment.
That's what this is.
This is a breach of contract claim.
But there is no breach of contract claim.
I agree, but Duff says there is.
But it's still a summary process matter.
It's not. This is not a judgment on a summary process case. This is a judgment on a breach of contract claim.
No, this is judgment on a summary process.
It's an order in a summary process, in a
Right.
breach of contract claim.
But the judgment is from a summary process matter.
Okay, I'll look at the rule.
I'll move past the untimeliness argument to get to the merits. With respect to this contract, this was a preliminary step and ultimate.
I'm sorry, before you do that, I should ask you to talk about what happened in April 2022, because it sure seems from the docket that in April 2022 is when the judge enters judgment on this December 2020 agreement for judgment, and there's a notice of appeal filed within 10 days of that. So why isn't that make it timely?
The appellants never pursued that appeal. They pursued this appeal.
How do we know which appeal they pursued? They filed a bunch of notices of appeal, and then this appears in front of us.
We know from their brief. On appeal from the Southeast Housing Court's order denying their motion to enforce settlement agreement. They
Right,
take
but that
no-
doesn't tell us which notice of appeal they're basing it on.
Well, then I believe it would be deficient for that purpose alone. I mean, they can't just file a number of notice of appeals and say, I'll pick the one that might apply.
I don't know why you
Because our
can't.
process is so clear that we spent the last 15 minutes arguing about it.
Yes, Your Honor. But that wasn't, the
All right, I didn't mean to interrupt your train of thought.
going to
You
the
can-
merits
You
of
can
the
go back.
Okay, moving on to the merits. This was a party by which the appellants were going to present a third-party contract. There was a 3-day response period. It wasn't met. For whatever reason, the holidays, whatever, what have you. But that issue wasn't raised at all during our communications after that the addendum was added to the purchase and sale agreement by the third party. And so our position is it's been waived with respect to the 3-day provision. When we were, and then the communications are within the record appendix, discussing, an addendum was added because this is a foreclosed property, and incumbent with foreclosed properties, there's other issues that you have to be aware of. First of all, the condition of the property. My client has never been on the property because it's a foreclosed property. So there's conditions that they want added into any purchase and sale agreement, like we aren't making any representations as to the condition of property. It's being purchased as is by the third-party purchaser. There are other contingent.
But why is that relevant? I mean, okay, did they refuse to accept that condition?
They did. They refused to accept the addendum. So if you look back,
Well, the addendum included something like, you got to pay our broker 30 grand, right?
no, there was no broker fees included in that. They make that argument. There was a broker provision that didn't include any number whatsoever. It didn't identify even in the HUD that was
There was
attached.
a broker provision.
A broker provision.
We'll use this broker, and at some point, there's a document that indicates that they've got to pay the broker fee.
No.
No, that's false. He wrote that in his brief.
There is a HUD, there's a HUD one attached to the addendum, and there is no broker fee because it wasn't a broker. There was no broker. This wasn't a listing. This is a negotiation.
I completely agree. It seemed like bad faith to me to put a broker in and ask that you pay a broker $30,000. In fact, there was a name associated with the broker, Greenfield something or other.
All it was a form provision in their addendum, their foreclosure addendums. It didn't list an amount. It says, you know, the amount listed in the listing agreement. There is no listing agreement. There wasn't a number identified in the HUD one. They take issue with a number of the fees in the HUD one, and if you look 7 days later, we removed all those fees and said, okay, here's a revision. Give us your edits to this addendum. By that point, they told us, buyer's walking. So if you look at the communications between the parties from January 26th through February 7th, when we provide the purchase and sale agreement revisions and addendum in HUD 1, there's no edits provided.
So this is an argument to me that says not it's unenforceable. We didn't breach.
Yes, absolutely.
What I'm hearing from you is the stuff that they're saying in their brief about breach, other than the 3 days, which we blew the 3 days, we didn't breach.
Absolutely. We are ready.
Okay,
willing,
so can we take a step in front of that, though? Is the agreement enforceable?
not with respect to purchasing it. So it's binding a third party that wasn't even identified in the contract.
It's binding you to sell the property for $600,000 if they come up with somebody who's able to pay $600,000 by a date certain.
With agreement on a purchase and sale. It says we have to present a third-party contract to you to review.
But wasn't, I mean, the purchase and sale stuff is stuff, that's the stuff of everyday life for folks who do what you guys do, okay? And it says, these are the fees that we're going to have, and you have the rest of them. What else really needed to be negotiated there? I mean, now aren't we now into the case that he relies on heavily, the one written by Judge Sikora? I don't have the name. I mean, wasn't there really agreement as to what the costs would be and how they would be shared?
With respect to the cost, yes, that was an agreed term. But
so what was missing?
well, apparently, and you'll see this in the communications, what was missing is a couple of terms. We added in a provision in our addendum said we would be the closing agent, okay? Doesn't seem like a big deal. They took issue with that. You'll see just the next day, I said, no problem, we'll waive that provision. Okay, what else is at issue? This broker fee. I said in my emails, there is no broker fee. There was no commission, there's no listing, okay? What else is wrong with it? Well, you have all these fees. It's supposed to be $6,000 with closing costs. Now, closing costs was undefined. I said, okay. We sent in a revised version with no $13,000 of closing costs. It was for $600,000. So I said, okay, what about the rest of the addendum? This is boilerplate. I'm not negotiating it. It's in a PDF form. I refuse to edit it. Okay, so are you going to go forward with the sale? No, our buyer is walked. And that was what happened. And so our position was, yes, it is boilerplate. But they refused to go forward with the purchase because their third-party purchaser, who was not a party to the agreement, walked. And we had no way to enforce it against them because he's not a party to the agreement.
I mean, the problem we have is that that's not what the judge found. Didn't find you didn't breach or didn't have a material breach. The judge found there was no such agreement in the first place. It's all an illusion, and if that's wrong, what can we do other than remand and ask the judge to figure all this out, all the stuff you're telling us now?
Well, because this is a de novo review, you could find that there was no meeting of the minds. And specifically, we agreed with that provision because of this third-party issue. Well, there's no way for us to...
Wait, say that again? I got lost on de novo review. I wasn't sure where it was. But you mean there's de novo review over whether the agreement is unambiguous, right?
Right.
Okay, so then what?
So we agreed with that because there's no third party identified in this contract. There's no way for us to bind this third party to buy the property. What could we do? All they had
bound to sell the property for a certain amount if they show up with $600,000 on a certain date. Isn't that enough?
And if they don't, you get the property.
Well, yes, but there's also the language in paragraph 3 that says it has to be a contract. There's got to be a third-party contract that's negotiated. Here, they just presented one. We came back, and so it's ambiguous as to there being a third-party contract. This is just a preliminary step. I mean, if you look at the cases that we cite in our brief, because the party's intent was to form a third-party contract, there was no current meeting of the minds with respect to the purchase, and that's the issue. So
I'm just having a hard time understanding the argument that because there wasn't an identified third-party purchaser, and we all agree, as long as the money showed up on that date, the deal would be agreed, that the agreement was really between the two of you, though.
it was, yep, to attempt to resolve all claims at that time. But there's no way for us to have enforced them to buy it, that agreement. I mean, this is a...
Right. Either he shows up with $600,000 from someone, in which case he gets to walk, gets the property, you sell it to him, and you're happy, or he doesn't, in which case you get the property, he has to leave immediately, levy on execution. Why isn't that an agreement?
Well, I think for an offer well, that is an agreement, but it's not an agreement that allows him to seek specific performance for the sale of real estate.
Oh, that may be true.
And that's what we're arguing. There is a binding agreement, but for the specific performance of real estate, there's no agreement because there's no identifiable third party that the seller can force the buyer to go forward with.
I just want to make sure I heard you correctly. You said there is a binding agreement.
Yes, with respect to the specific performance of real estate.
To the settlement, but not to the actual transfer of the real estate,
Correct.
is your position?
Yes.
Okay. All right, well,
If there's no further questions, I'll rest my briefs.
thank you both. This is a complicated case, and this argument has been really, really helpful to us in understanding this case.
Thank you, Your Honors.
Very grateful.
Very well done.
All right, the next case is 23P 388 Cutting Edge Homes versus Mayor. I'd like to say before we begin that we're very appreciative of both of you coming and arguing. We really had some questions about this case, and it's always heartening when the court asks for the assistance of attorneys, and attorneys are happy to come in and assist us. So thank you very much.
Thank you, Your Honor.
Whenever you're ready.
Good morning, Your Honors. May it please the Court, James Simpson on behalf of the appellant Cutting Edge Homes. This appeal centers on essentially one claim that was left in this matter. It was the interference with the advantageous business relations. The trial court determined after summary judgment that there was no material facts in dispute as to this claim and entered judgment in favor of Mr. Meyer. As a quick background, I know you have indicated you've read the briefs, but there is a lot of factual surroundings in this case, which I think is pertinent to this argument. Essentially, my client was a general contractor that was retained by the homeowners to remodel.
Yeah, I think we've got it, so let's jump in, okay?
So essentially,
If I could.
Yeah.
What I want to know is, what do you rely on that shows improper means? What documents in the record or testimony show improper means? Because I took a quick look, not as deep as I should have gone, at the email chains from Mr. Mayer. I don't know if it's Mayer or Meyer, and what I'm looking for is an indication. So let me back up and just put my cards on the table. Judge says negligence is not enough, and we know deceit is enough, okay? Are you saying that it was deceit or something less but more than negligence, and where's the evidence of that?
I think, Judge, I agree with you. It's more than negligence. It doesn't go to the level of deceit. That doesn't jump out at you. But my position is that over the period of time that Mr. Meyer looked at the bills that my client submitted to the homeowners, and he would, in his own words, in each instance, say, he's overbilling you, they're overbilling you. And over months and months and months of that being played out over time.
How many of those statements are there? They're overbilling you. I saw a couple. I saw a reference. I saw the $500,000 one, right, where he says, oops, I made a mistake. It wasn't 584, it was 300 and something. But he says in that same document, that's bridgeable, which seems to me to be something different than these guys are cheating you. In October, he gets there, and he calls it a joke, and he's been making it up all along. Is there something like that before October?
Well, I think it is in the undisputed statement of facts and in the judge's findings in the trial court level, in every instance, he made that determination that they were being overbilled. And over time...
But what does he say? What should I look at where I'm going to say, oh, on that document, on that date, he says, they overbilled you by X amount?
I think, and when you started talking about specifics, like there was the elevator project where there was some email correspondence back and forth between Mr. Meyer and the homeowners, and he's saying, listen, you guys paid in full for this elevator project and nothing's been done.
What was the date on that?
That was, I believe, in September of 2019.
Okay.
And
what else would you point me to other than the elevator document?
And then there was the issue with stairway in some remodeling work where a deposit had been put down by the Shapiros. And he claimed that my client basically hadn't done any of the work, he basically said, I don't have documentation that this deposit that you paid was forwarded to anybody. So he just naturally concluded that my client just put the money in his pocket and nothing had been done. And knowing the nature of construction work, oftentimes to retain people or like to get them to do the work, or they have to buy materials, money has to be fronted, and it doesn't necessarily show up that work has been done, especially like with an elevator. You have to basically pay for it almost in full before it's even brought to the property.
Okay, are there others? So we've got the elevator, we've got the staircase.
Those were two of the essential ones. The rest of it was just basically this, he's overbilling you, and he's off by this. Oh, wait a minute, he's off by 5. Nope, he's only off by 250. And the fundamental problem with his analysis was it was apples and oranges. You know, the contract between my client and the homeowners was not based on this percentage complete, which is an AIA
Right, so that's the
standard.
third piece. So what do we have in the record that I should look at so you're, as I understand it, you're saying, look, our contract was set prices on set dates. Mr. Mayor comes in and he says, hey, you're not doing this right. He's way ahead of you because Mayor is assuming that it has to be on a percent complete basis because that's the way he does things, and that Mayor never read the agreement? Is that part of your case?
Yeah, I mean, in his deposition.
How do we know that?
In his deposition testimony, he did admit initially when he was performing these calculations, he wasn't aware of what the contract spelled out between my client and the homeowner. Subsequently, he did find out.
When did he finally find out?
It wasn't until later on.
What day?
It was in the late fall of 2019 that he learned, or he knew that it wasn't based on a percentage complete. But prior to that, he hadn't actually seen the contract.
How is it that when he's complaining starting, and they're talking to each other, I see that in the emails, how is it that Mr. Cutting doesn't say, hey, I don't have to do this on a percent complete. I got an agreement that says the opposite. I mean, is there any record of this?
Their only record is there was a July 2019 conversation between my client and Mr. Mayor where they basically had a hashing out of what was going on, and my client agreed to then start to put the payment requisitions in a format that Mr. Meyer was familiar with.
Well, presumably at that time, your client also said, by the way, this isn't what the contract required.
I wish the record was clear on that, but there was no specific indication via emails that they actually had that straight, breakout conversation. But at that point in late July, my client then tried to convert his system into what Mr. Meyer's system was based on a percentage complete, and he sent spreadsheets and requisitions that way, and it still didn't solve the problem, so to speak, and there was always a dispute as to what the percentage complete was on the project versus, Mr. Meyer's version or my client's version. And over time, this was a project that started off, with a $2.1 million price tag, and then it just exploded into a much larger scale.
Never happens in my experience.
Yeah.
So can I just, I'm having a difficult time understanding, as Justice Englander pointed out right from the very beginning, where the evidence, the willful deceit type of evidence is. Because what you've explained earlier as examples with the elevator and the stairs, to me, seem to be like typical kind of contractor squabbles that happen back and forth. The fact that Mayor mistakenly believed that the calculation for billing was different than it actually was doesn't, to me, show evidence of intentional harm. Because this is just a one claim remaining against Mayor, right? And to me, that basic allegation of intentional interference, torturous interference with a business relation, has to be more than just, sorry, you're a jerk, you didn't read. And not reading the contract seems to me not intentional, the opposite of intentional. It seems to me to be like, I didn't read it. I just thought it was the way that I always did things. And this back and forth about the stairs or the elevator doesn't seem to me to be, my God, when you look at tortious interference with business relations, it means you meant it. You're doing something, you're showing me evidence of means or motive that says, you're trying to mess with this person's livelihood. That's why we allow you to sue. If we allowed everybody else to base a claim on tortious interference with business relations by saying the bill should be X versus Y and the stairs or the elevator should be this or that, it would be every contractor in the face of the planet, right? I don't see where the evidence is, and tell me why I'm reading that wrong, but I'm not seeing it.
One of the other factors in this case that was going on during that summer when they had this discussion, shortly thereafter, Mr. Mayor was contacting another GC to replace my client, someone that he had worked with before and had a relationship with. So all the while, my client's still doing work on the project, yet Mr. Meyer is going behind the scenes and trying to get another contractor. The homeowners are asking my client in that late fall to give them a proposal to do more work. And then all of a sudden, 2 weeks, 3 weeks, 4 weeks later, they get a letter from the attorney saying that you're off the job. There's some dispute whether my client left, but there was certainly a breakdown of the contractual relationship. My client had an expectation to perform under the contract. He was doing the work, albeit not maybe at the pace that the homeowners preferred, but he still had a lawful contract.
So calling competitors is an intentional and willful, deceitful act that would give rise to a triable issue on motive or means?
I think if you're just saying, listen, I'll take a look at the bills and see what's going on, but the editorializing of the billing and the statements made, it ruined the relationship between my client and the homeowners. And over time, if this was just a one-off thing and it happened once or twice, but this was something that occurred basically from the time that my client started working on the job and Mr. Meyer was tasked with, overseeing.
What do you think the law is with respect to what is required to show improper means? You agree that it has to be more than negligence?
Correct, it definitely does.
And negligent misrepresentation, a false statement, but it was negligently done. That's not enough.
I agree.
Okay, so is recklessness enough?
I think it's slightly above recklessness. I think he needs, in his behavior.
I'm not sure that I can get between recklessness and intent. What's the word for that?
If I may.
I believe it, he did more
Can I try
than
this
just.
from a different angle? So Blackstone tells us that under certain circumstances, corporate official, there's a elevated standard. It has to be a spiteful, malignant purpose unrelated to legitimate corporate interest. Do you believe that's the standard that applies here, or that's not?
Yeah, I mean, he was asked to do some review, and just a mere review is fine, but then editorializing it and then adding stuff and then going behind the scenes and trying to get another contractor to come in who he was familiar with and had worked with. I think he goes beyond, he makes that extra leap.
But do you think that's the standard, or are we on the United Truck standard?
Well, I think the law is somewhat back and forth on that. I know on, what was the other case? They said malice was not necessarily.
You don't need malice.
Yeah.
Right. But I think this is, for me, this is the nub of the problem. What case would you rely on?
Well, I think.
For us to develop a standard for this that's less than intent, specific intent, because there's general intent, right? I mean, he intended to write what he wrote. But specific intent to interfere with the agreement, that could be a standard, okay? What would you rely on to say it's something less than that?
Well, I think the restatement of torts gives you some questions to ask getting into that, albeit not perfect, but I think a more...
Does it tell me that it could be less than specific intent?
I believe if you look at the questions and answer them in the factual scenario such as this, I think you can get to that point. It's just, I think given the whole factual scenario in this case and the length of the time that there was this constant editorializing and communication.
I understand what you're saying the facts are. What I'm trying to get at is what the standard is. And it's always been elusive. And that's why I'm asking the question, what cases should I look at? Or you say look at the restatement. But the restatement gives me, if it gives me a list of non-exhaustive factors, it doesn't tell me, is something less than specific intent enough?
I mean, I do think United Truck, although, from 1990, it still is persuasive on this. There hasn't been a ton of new case law on this issue. Maybe that's because it's been believed to be set in stone what the factors are. But I do think United Truck leasing is something that does offer, what should be the standard. Beyond that, Judge, panel, that's essentially my argument. Is one issue that's left in this case out of all the other claims. And if there's no further questions, I will rest on my brief.
All right. Thank you very much. We'll hear from the defendants now. Whenever you're, it's whenever you're ready.
Thank you, Your Honor. May it please the Court, my name is John Callan. I represent the defendant appellee, Alan Meyer. As this Court's aware, the trial court did enter summary judgment on this claim of intentional interference with contractual performance. I ask that this Court affirm that judgment. I believe Judge Layton had it completely correct. He found all
Well,
three.
he didn't have it completely correct. Are you still saying causation was, that there was no evidence of wasn't it insufficient evidence of causation to go to a jury?
There is no evidence that was presented in the summary judge record.
What about the lawyer's letter? The first item in the lawyer's letter is overbilling. How could that not be sufficient? Coupled with the other evidence that he's marshaled.
Yeah.
That the statements that they were being overbilled caused them to breach the contract. Or to, I don't know, breach is, yeah, I guess it is breach, but not illegal breach.
Yeah.
Would be.
I would submit, Your Honor, that the evidence was just not there. That's a letter from the attorney for the buyer, I'm sorry, for the attorney for the homeowner.
For your client.
No,
not for your
I'm sorry.
client.
No, he
I'm sorry.
represented the homeowner.
Right, but it okay.
What about Ronnie Shapiro's deposition testimony, where he's asked how this broke down? Alan was right 100% of the time on everything. Alan helped me understand the project in a much clearer light. He was showing me that I was overbilled. He was showing me the workmanship wasn't good and showing me the time frame would never, ever be what Sean had promised us. Why isn't that? I know that the Sharon has a completely different story on why they fired the contractor, but for summary judgment purposes, why isn't Ronnie's testimony enough?
Again, I would submit to the court that the reason that Cutting Edge was terminated had nothing to do with what Alan Meyer did. Alan Meyer was asked specifically to review the requisitions from the contractor and advise the Shapiros on whether those requisitions were properly documented and reflected the work that had been performed.
If that advice caused them to fire Cutting Edge, doesn't that at least get us causation? Whether they get to spouse is a different question.
No, I think he acted in good faith for a legitimate business purpose and came to a legitimate conclusion based on his
Well,
experience as
that
an
goes to
architect.
improper means, not to causation.
Not to causation, yeah.
So if we take causation and just put it aside for a moment, can we focus on the improper means or motive?
Yes, I'd be happy to, and I think that that is the key here. There really is no evidence of any improper motive or means. The courts have described this in a variety of ways, but there's got to be something more than mere negligence.
Hey, we agree with you there. So what do you think the standard is? Well, or at least I do. I can't speak for everybody on the panel, but
Yeah, well, there's a variety of factors that go into this determination of whether there was improper motives or means. For one, it requires a finding that there's been some deceit or some economic coercion. There is no evidence of that.
is there a case that says it requires a finding of deceit?
Yes, I believe that's the Horn case and the Schwanbeck case, which I've cited in my brief. That goes to the component of improper conduct.
What are the two cases you would point me to?
Horn v. City of Boston, and that relies on another, that's a federal court case that quotes from an appeals court case called Schwanbeck. Improper conduct, quote, may include ulterior motive, e.g. wishing to do injury, or wrongful means, e.g. deceit or economic coercion. And there was no evidence that was presented on the summary judgment record as to either of those components.
Deceit or economic coercion? What about you just don't care? You don't bother to read the agreement between the actual agreement that the contractor is operating under. Instead, you just get started saying, oh, I think this is all wrong. He's overbilling you by $250,000. Let's call that recklessness. Is that enough?
I don't think there was recklessness, but even if there were, you need to show that he acted improperly. He had some motive here to undermine the relationship. I don't think that's been presented. That was not presented
No,
on the
now
summary
you're
judgment.
mixing motive or means. It's
It
motive.
be both.
It has to be
Improper motives-
both?
I take that back, Ronnie. He has to establish that there's an ulterior motive, which could be either improper means or improper motive. I don't think they've shown either. There is just no evidence that Mr. Meyer acted deceitfully, that he engaged in any sort of
So
coercion.
you think the tort, and I've heard my colleague over here do a very good description of what the issues are if you make the tort too broad. But you think that the tort does not encompass conduct that interferes with someone else's contractual relations where the person acts recklessly. They're in a position where they've been asked to comment on the contract, and without really giving a darn, and this is hypothetical, I'm not saying that this is what has been proved by any stretch. I'm just asking the question. They just don't care. But they're in a position to affect one of the contracting parties, and they just start saying stuff.
To my knowledge, I don't see any of the case law.
Tortious conduct within the contemplation of intentional interference with contractual relations.
I don't think I'm overstating this. I do not recall seeing any case that talked about recklessness as forming the requisite type of behavior to satisfy the standard for intentional interference.
You know, they struggled with this in the securities law context, and they came up with this word scienter, which I'm still not sure where it falls between recklessness and intent, or if it does. But that scienter is a state of mind that has some piece of intent to it, right?
Some formulation of a motive to do something adverse to another party. I think it's important for the court to understand as well that this was not in a vacuum. There was discussion between Mr. Mayer and Mr. Cutting. Look, I don't see how your numbers add up. Look, I need some evidence that you paid this contractor. That's not the kind, and this is what Judge Layton commented on as well, that's not the kind of conduct where somebody has it out for another party, where they're actively trying to get them.
So the motive has to be to harm the plaintiff, right? So in other words, if Mayer, let's just suppose, really wanted to have his best friend be the general contractor, didn't want to necessarily have anything motive to harm, but they really just wanted their best friends to be the general contractor. That's not improper motive toward the plaintiff, correct?
I would agree.
And when we look about the means, I mean, the restatement of torts says, and I'm asking if you agree with the restatement of torts, innately wrongful, predatory in character, in order to survive under one of the two prongs. Do you agree with that description?
I believe those descriptions are consistent with how the case law has formulated this tort. I know there's been some back and forth as to what portion of the restatement is being applied in Massachusetts, but and it's sometimes a little hard to follow what's improper means, what's improper motive, but those kinds of characteristics where there's something above and beyond simply I didn't understand the terms of the contract, or I don't care even about the terms of the contract. That's not the kind of conduct that this tort encompasses. And there was no evidence presented in the summary judgment record to suggest anything more.
So the rough and tumble of business is such that you have to be able to protect yourself. The plaintiff in this case had to be able to protect himself against the conduct of a third party that is unintentional.
I think that's right. I think the fact that there is some latitude given to the fact that there is a free marketplace out there, that you don't necessarily have to be bound with one contractor or another, that even if you have a financial motive, even assuming Mr. Meyer did, I don't think that formed part of his actions here, but even if he had a financial motive, oh, I can get more money if I work with my buddy, the other contractor, that's
There's no
perfectly
proof
okay.
of that, right?
I'm sorry?
There's no proof of that. There's no proof that
No,
he made some, he gained some financial benefit as a result.
Undisputed that he did not.
It's undisputed that he did not?
Correct. He did not receive any financial motive for referring the project to Benchmark Builders, the replacement contractor.
And he wound up not supervising with the new contractor, is that right?
He did not supervise a new contractor, that's correct. There was no need to, essentially. I have nothing further unless the panel would like to
All right.
pose other questions for me.
It's a lovely part of town.
Indeed.
Just driving by yesterday. Not on purpose, just happened to be. Thank you both. This has been really helpful. It's a really interesting case, and again, we really appreciate you coming out here and presenting in front of us. All right, I'll call the third case, 23P 148, BELLMAR versus Moore Family Practice. All right, we'll hear first for counsel from the plaintiff. For the plaintiff. Whenever you're ready.
Good morning, Your Honors, and may it please the Court, Terrence Hurry on behalf of the appellant Lorraine BELLMAR, personal representative of the estate of Harry BELLMAR. We're here before you this morning asking you to consider whether the Superior Court erred in granting summary judgment to the defendants on plaintiff's claims of negligence and wrongful death by holding the medical malpractice statute of repose, GL's 260, Section 4, whether it bars all claims for malpractice that allegedly occurred within the 7 years prior to the commencement of the civil action, if there was malpractice that had also occurred more than 7 years prior to the commencement of the civil action. Following the court's decision in Moran versus Benson, the defendants moved for summary judgment, and the Superior Court granted judgment via memorandum and order on October 21st, 2022. Regarding the relevant facts of this case, the defendant, Dr. Robert Morse, he was Harry BELLMAR's primary...
We're familiar with the facts. Why don't we get right to the argument, please?
Of course, Your Honor. In our brief, we maintain that Moran improperly provides an immunity from suit for negligent actions causing harm within the statute of repose.
You're asking us to overrule Moran?
Yes, Your Honor.
We can't do that.
I would suggest to you that it does expand the scope of the medical statute of repose. The object of the statute of repose is to suppress fraudulent and stale claims from springing up, and that's Jocelyn v. Chang. There is precedence. Granted, the fact pattern of a case was different, but in Penn American Insurance Company versus Bay State Gas, which was 96 Mass App Court 757 in 2019.
So let me just make sure I understand, because we can't directly contradict a precedent of this court. At least that's my understanding. So is it your view that Moran, as it's written, means that you lose?
Well, essentially, Your Honor, it expands the scope of the medical statute of repose. And we did reference a case from South Carolina regarding that. But this court had previously decided Penn American Insurance Company. The plaintiff's claims against the defendant arising from the alleged defect in the defendant's natural gas line was time barred by the 6-year statute of repose for real property. This court held that the legislature's intent of the statute of repose did not apply to that plaintiff's claims, which were related to the defendant's continuing duty to maintain its equipment.
So let me interrupt for a moment. Would you agree with me that if it was just the 2006 abnormal EKG and failure to refer to a cardiologist, if it was just that, the statute of repose would apply and the case would be time barred, correct?
I would agree, Your Honor.
Okay.
But
No, just work with me for a minute. Okay. So that one's gone, right? If it's just that. And if the facts were, because sadly, Mr. BELLMAR died very young in 2016, but let's just say between 2011 and 2016, he went to the Moore family practice, and every year he'd go, he'd say, my heart is killing me. Every time I walk upstairs, it's harder and harder. And every year, the doctor kind of twiddled his or her thumbs, said, keep on your hypertension medicine, we'll get you a new sleep machine or whatever, and never referred or never did whatever, just this, you would have a cause of action, correct? Okay. What I don't see in your argument, which I think is the problem here, is that everything in your complaint, and tell me where I'm wrong, hitches this whole train to the 2006 failure to refer or do anything more on the abnormal EKG. So that's the event. And then everything else, just like in Moran, the continuing symptoms, the other types of symptoms were as a result of the 2006. Now, had I read in the complaint separate acts of alleged negligence, medical malpractice, my thought would be, well, whether 2006 comes into a trial is an issue for the Superior Court judge, but for this issue on the motion for summary judgment, I see here, or maybe in an evidentiary hearing, the Daubert hearing, that yes, there is evidence of malpractice. So I'm not sure that this whole legal framework has to be overturned. It seems to me to be particular to this case that I don't see it in your complaint, and I don't see it anywhere in the record that you have unhitched your pony to the carriage and tried to ride off on the 2011 to 2016 alleged malpractice by Moore Family Practice. That's what I would love for you to address.
Understood, Your Honor. Thank you. In the complaint itself, on paragraph 11, we do refer to the dates of service, and in paragraph 12, we do note that there was no documentation to suggest that Dr. Moore ordered or made any other referrals. And that's the issue here with negligence when we're dealing with omissions.
So we're hitching it to the 2006 failure.
I think you're saying that you've alleged negligence each and every time that he came to the practice?
Essentially, yes. There were multiple instances.
Well, it has to be yes, and there has to be expert testimony to support it, correct?
Right.
And is there expert testimony to support the notion that each and every time that Mr. BELLMAR came, that Dr. Moore committed negligence?
We do have our expert, Dr. Pells. He did originally opine on Dr. Moore's failure to follow up on the EKG back in 2006, but he further opined to the standard of care regarding the abnormal EKG and the years moving forward from there. In that 10-year period...
Let me back up. I had an opportunity to review that transcript, and in fact, he seems to have said no. For example, the one doctor's meeting where Mr. BELLMAR said, or there's a notation of my heart being hurt. Even your expert says, that's not enough. Just kind of one more, kind of my chest feels a little bit tight. So, separate and apart from a continuing duty of care that doctors owe their patients. That just that, one additional notation in a record wasn't enough to establish an independent factual basis. That was your expert.
As part of in the transcript, yes. I would also refer you to the joint appendix, Exhibit C, that's part of the Record Appendix 1. That would be Dr. Pell's July 17, 2017 correspondence. He did opine on the standard of care, again, originally following that abnormal EKG. And he had mentioned that had Dr. Moore followed the standard of care by making the appropriate recommendations to follow up with a heart expert, monitoring, perhaps a stress test, then treatment would have included for the arrhythmia, for the coronary artery issue and the blockage.
But it was the 2006 EKG that meant that at each point he should have done that, as far as Dr. Pell's was concerned, as far as I could tell.
Correct.
And does Dr. Pell's ever do this? Does he ever say, after 2009, if he'd done those things, there would have been a different outcome for this patient?
In that July 17, 2017 correspondence, he did note, had the standard of care been followed, again, with making the appropriate referrals and the appropriate testing, that it would have prevented Mr. BELLMAR's premature
He
death
says that with respect to...
by 10 to 15 years.
He says that with respect to the 2006 event, which is outside the statute of repose. Does he ever say, if he had done that after 2009, it would have causally affected a better result for Mr. BELLMAR?
Right. Well, my interpretation of his correspondence was had Dr. Moore followed the standard of care throughout that time period, then the answer would have been yes. It would have prevented his premature death and would have extended his life by about 10 or 15 years.
But you remember the earlier example of if we unhitch these two and we, for a second, just ignore the 2006, and we're just focused 2009, 10 to 16, all by itself, with nothing else. I don't see it, and I've pored over the documents, but please tell me what I'm missing here, because if that was the case, then I think that the ruling in Moran wouldn't necessitate a ruling against you, right? If there's malpractice in that 6-7 year period of look back and you have expert testimony and alleging it, I think you have a case to go to a jury. So what, point to me what I'm missing here. If I want to put blinders on, right, for that, that's how I look at the statute of repose, right? It's just look right there. Tell me where independently you've got it and I've missed it.
It would be Mr. BELLMAR's underlying health concerns, his morbid obesity, his hypertension. These are all risk factors for cardiac disease. And even if Mr. BELLMAR had a regular EKG in 2006, his underlying risk factors would have warranted additional tests regarding cardiac disease.
Where is that in Dr. Pell's? I didn't see that. That even with a normal EKG, it should have been ordered. I didn't see that.
Record Appendix Volume 2, 109 through 111.
Is that a Pell's report? Or is that a transcript?
I believe that's the transcript.
So I'm sorry, Record Appendix 10,
Volume 2,
yep.
109 through 111.
So it might just be a, 109 is not that. Okay, it's
Even if you had a normal EKG in 2006,
yeah, I think so. That's right. Got it, thank you. Okay, thank you.
yeah, that's what it says.
So I see where you're referring to that passage in his testimony. I guess it still seems to be missing in the complaint. Is that a problem?
Missing itself in the complaint?
Any allegation that it was just, he should have done, independent of anything in 2006, that somebody who presents themselves with hypertension, sleep apnea, and obesity, that it was malpractice,
Right,
not have done other things.
Right, and again, that's the issue that we've had with omissions in the complaint itself. We did reference the date of services in paragraph 11. Paragraph 12, we stated that there was no documentation to suggest that he ordered any additional testing or made any additional referrals.
The transcript we're reading, is that from the Daubert? Or is that from his deposition?
That's from the deposition. I'd say in closing, Your Honors,
Now,
this
hold
court-
on, so this is in volume 2, and at least in the table of contents, it says Exhibit F, excerpts of Dr. Pell's Daubert hearing testimony. And then it starts with hearing before the Honorable Greg Pasquale.
Yes, so that would be the Daubert hearing.
So it wasn't a deposition.
That's correct.
How did
My
that, how did the
apologies for
Daubert come up? So there's a Daubert motion and Pasquale, Judge Pasquale decides to have a hearing sort of before trial. Is that what happened?
That's correct.
So it's just sort of a separate hearing in connection with a statute of repose motion?
The Daubert hearing came first, and then following the decision in Benson, then the...
Did he ever rule on the Daubert motion?
Yes.
Maybe Daubert, I don't know. It's an ongoing debate. Did he ever rule?
Ruling in the,
I believe the ruling was that Dr. Pels could testify.
Okay.
thank you.
All right, well, thank you very much.
Thank you, Your Honors.
We'll hear from the doctor now. Whenever you're ready.
Good morning, Your Honors. Stephen O'Shea on behalf of Robert R. Moore, MD, and Robert R. Moore, MD, PH, PC. Geez, I thought I wasn't going to have to say much there for a while. But the last piece that just came up, it was testimony from Dr. Pels at the Daubert hearing that I had requested. It was testimony elicited by plaintiff's counsel, sort of backdoor because it was beyond the scope of the expert disclosures that we had and would use at time of trial. The long and short of it is I don't think it makes any difference because when you look at the language that you were just referring to, there's no standard of care language. There's no he deviated from standard of care by not doing this. He simply said, and it was in the context of the risk factors. So Mr. BELLMAR had cardiac risk factors from basically the 2006 when that EKG was done. And Dr. Pell's opinion all along has been that the failure by Dr. Moore was not to recognize the abnormal EKG in conjunction with those risk factors and do something about it. And by do something about it, it meant order further testing. And so the comment that even with a normal EKG would testing be warranted, that doesn't get them to where they need to be. They still need to have expert opinion.
Can we just step back? I understand your point. Can we just step back? Do you agree with an earlier exchange in which it was suggested that if there was, so 2006 happened, okay? If there was post-2009, whatever date in 2009 is 7 years before death, there was another event of some sort. For example, I had terrible chest pains the other day. You know, I was playing tennis and I was flat on my back and my heart was pounding like crazy. And your client did nothing about it. Does he have a claim?
It depends. So
On
it
what?
depends on, do you have an expert who is going to analyze that issue and formulate an opinion, more probably than not, that the doctor deviated from the standard of care and that that deviation likely caused the patient harm.
Okay, so, yeah, so you then are, I don't want to use the word concede, but you're willing to accept the notion that even though 2006 happened, something happens within the repose period that a doctor says, that right there, then that was cause for him to act. That's enough, and that claim can go forward.
What I would say is that it's not clear, and I think I addressed that in the brief. I don't think Rudenauer says that. I certainly don't think Moran says that. I don't think that we've had an appellate court case in Massachusetts that has really addressed that issue as to whether there can be multiple definitively established events, and if so, how far apart do those events have to be? I mean, if there's some similarity or if it's black and white that, you know.
If it's not similar. Patient goes into the doctor's office in 2012 and says, my right foot is killing me. And the doctor amputates his left foot, right? And we get the doctor to say that's deviating from the standard of care and that caused him harm, right? You're going to be on the hook, at least facing a jury explaining why the jury shouldn't enter a verdict against your client, right?
Right.
Okay. So if in 2011 the patient comes in and says, my heart, walking upstairs, doing whatever, and it's 2011 and it falls within the time in which the statute of repose says you can bring it, and they meet the criteria, you're saying it that it may not be able to be go forward because guess what? In 2006, the doctor was really awful and committed malpractice. But we're going to sweep all this other stuff under the rug. That doesn't make any sense as a public policy point of view. 2006, sure, because of the public policy of the statute of repose. 2011, when he sits there and says, I'm getting the big heart attack this time, I can feel it coming, doc, and the doc says, just go out and take a walk with your doc.
And I'm sorry, are we talking about the patient with the missing left leg?
No,
and then we're
missing
having
left
the
leg,
heart?
you're going to trial, right? You're going to agree with me on that one, right?
What's that?
The missing left leg, if there's negligence and an expert, yes.
Yeah.
So when we have two of the same types of symptoms in two separate time frames.
Right. And I understand what you're saying, but the way, frankly, the statute can be construed, and you just look at the language, first three words of that statute, in no event, right? And then it's, shall any action be commenced more than 7 years after occurrence of the act, omission, which is alleged cause of injury. So it's, you have to get into the weeds depending upon the facts.
I don't think that statute says anything about the hypothetical that Judge Walsh just gave you. I mean, the hypothetical she just gave you is that there was something that happened again inside the statute of repose. Statutory language doesn't tell you that you would eliminate that simply because something had happened outside the statute of repose that was similar.
And I'm not
But
fighting
that's
it.
the nub of the problem here, right? The nub of the problem here is, what do we really have an opinion on from Dr. Pelz with respect to what this doctor should have done inside the statute of repose? You agree with me on that?
I do.
Yeah. And, I mean, we've spent a fair amount of time looking at this, as you can tell, all three of us. You know, he didn't say, I was on a tennis court and I fell flat on my back. Instead, he came at some time, I think in 2012, and he said, I felt some tightness in my chest. Now I'm going to assume a hypothetical, if Dr. Pelz had said, hey, he needed to get an EKG right away, And had he got an EKG right away in 2012, it would have avoided the result of him dying from a heart attack in 2016. Enough?
Different case. Right?
Different case, because that's not in the record, what I just said, right?
Absolutely to the contrary. What he said was there were no signs or symptoms at all that warranted any additional testing. And so it's not just that he didn't comment on it.
But was he confronted with, did he say that in response to, hey, in 2012, the guy reported chest tightness?
It wasn't in response to a direct
Yeah, I know,
focus on that
because I'll tell you,
issue.
I think that,
It was, were there any signs or symptoms, or are you just opining that further testing was necessary because of the abnormal EKG and the risk factors? And he said there were no signs or symptoms that warranted that testing. And that would include, and he had the record, everything within the record. But above that, your point is absolutely correct. To even make the claim, you've got to state it. You've got to have an affirmative expert opinion opining that something happened. And the language is definitively established event. Some definitively established event had to happen between
why is that, though? I mean,
2010
why
and
isn't it enough to
2007?
say, he had an event in 2006, and the doctor knew that he had a patient who was obese, had sleep apnea, had hypertension. He needed to be continually monitoring his heart situation.
That's
And had he
continuing
done so,
treatment.
things would have been better.
That's the continuing treatment doctrine that this court and the SJC has repeatedly rejected.
Okay.
There are, and that's the first issue. I know that you've read the brief, and the ancillary issue, I would say, but frankly, maybe even more crystal clear issue is one of causation. And so Dr. Pelz admitted in his testimony at the Dalbert hearing that there is no way anybody can tell when the microscopic fibrosis...
I don't understand this point.
Yeah. So what happened to Mr. BELLMAR is he had sudden death because he had microscopic fibrosis of his
No, I understand that part. What I don't understand is why this had to be within the 7 years. I mean, we have an opinion of causation from Pelz. He says if these acts had been taken, if you'd referred him to a cardiologist, this would likely have happened and the result would have been better. And that's a causation opinion. I don't understand why what happens to the causation opinion, in your view, because of this, the fact, which Pelz freely admitted, that he passed away from something that could only at the time have been solved with a cardiac defibrillator.
You have to be able to show when it could have been solved, when it could have been prevented. And the only way to prevent it is to prevent it from forming.
Why do you have to have an exact date if you have a doctor that says, had he acted, there would have been a better result? He would have lived for 16 more years.
He doesn't say when. Doesn't say acted when. That's another fundamental failure of Pelz's opinion.
Okay. Okay. I understand the point.
I mean,
And
you need
then-
something basically saying if he had acted within the repose period, it could have solved the problem.
If he had said that, and he really couldn't. As a matter of medical science, they had an autopsy.
Well, how could he
done.
say it about, this is what I don't understand. How could he say it about 2006 but not about 2009? Your position seems to be he couldn't make the causation position at any time.
Which was part of that Dalbert hearing.
That was rejected by the judge.
The judge denied the motion to preclude his testimony, but he allowed or said language to the effect of motion in limine, pretrial motion on the statute of repose issue.
I now understand your point, which is what I was trying to get at. That's it seems to me to be quite a sweeping proposition, because you're saying basically Pelz's entire causation opinion, even if it was done in 2006, was invalid because he couldn't establish an exact date. That's your argument.
It's true.
Okay.
Never said more likely than not 2010, 11, 12. And he said he couldn't say whether it was 2006, 2007, 2008,
But if a doctor with the credentials, the proper credentials, comes forward and says, if he had acted in 2006, the result would have been better, I don't understand how we're going to throw that out. Because he can't tell you the exact date? He's saying if it had been done then,
Because we identified the precise cause of Mr. BELLMAR's death, which was that microscopic fibrosis. And so the question then becomes, from pathology, what was the date of that fibrosis? Because we know every one of his risk factors could have caused or contributed to that independently. And so, and you may recall this in Pell's
did
testimony.
you have an expert who said this?
Yes, I have a cardiac pathologist. We had the only cardiologist identified to testify at trial. And I believe he did address that. The timing
okay.
is not knowable.
That's not what he testified to at the Daubert hearing. He said if you started at 2006, in his opinion, it would have helped, right?
What's that?
I understand you don't like the opinion, but if any additional testing or treatment had been instituted after, say, 2006, it would have been speculative to say whether it would have been enough to prevent the progression of that substrate that triggered his, I'm not going to try to pronounce it, to the point where it would have prevented his death, right? I assume that's you asking. And the response is, I disagree with that. And considering that I'm speculating, it's my medical opinion that it would have.
From 2006 on, which isn't
Right, I understand
enough.
that's a problem proposal-wise,
I didn't have to dig into it any further. My cardiac pathologist was telling me there's no way that you can date that thing. There's just not science.
But he seems to be saying if you'd done it right at 2006, it would have stopped the progression of the disease.
Which doesn't help him.
Right.
Even if that's
So I
true.
understand
the
it.
statute, right.
Yeah, I get the statute problem. I just make sure I understood what I was reading here. All right,
Any
anything?
further questions?
I think we got it.
Thank you.
Thank you both. This is actually a pretty interesting case, and this was very helpful for us.
3 for 3. On to 4.
Well, I think before 4, we will take a little break.
Sorry.
And it will truly be no longer than 15 minutes. Just one second. All right, calling our fourth case, Quidley versus Burke, number 22P 926. Counselor, whenever you're ready.
My name is Sandy Durland. I represent Patrick Burke, the appellant in this case. Good morning. As your honors are aware, I raised 3 discrete issues in my brief. The exclusion of a federal pension from the divisible marital estate, the division, of the assets, the failure to properly account for upwards of $500,000 of cash withdrawals from a thrift savings plan, a qualified plan, and the order of a joint tax return for 2020. Now, I can address all 3 issues for your honors, or unless you have any questions you'd like to ask me straight away.
I'm sure we'll have questions.
Why don't you proceed?
Okay. So starting with the pension, which is the largest issue, at least insofar as my client is concerned. Now, the judge made clear that he intended an equal division of the marital estate.
Is that clear? How is that clear?
Well, I mean, he made that finding. He said it was a true partnership. They had a plan and they followed it. It was apparent to me, and I think it's apparent from the judge's findings, that that is what he intended. Now, I tried to sort of reconstruct that in my brief, and I did come out roughly at 50-50, depending on how you treat that pension. So I do believe it was intended clearly as a equal division of the assets, but the
Well, okay. So one might argue differently, but it really gets to this debate that the two of you are having over the $250,000 that were taken out of the thrift savings plan. Didn't the judge understand that when the judge picked the number 1.247 million to split, that actually there was no longer 1.247 million in the account?
That's the thrift savings plan.
Yeah.
The pension is what I was addressing.
Right, but we're talking about whether the judge actually split the baby, as you're suggesting, and if the judge was splitting a number that the judge knew was not accurate and favored your client because he was giving your client $600,000 and giving the other client, the wife, $400 and something thousand. I mean, you know, I'd like some resolution on that. Didn't the judge understand that there wasn't actually 1.247 million, that 250 of that was gone?
It's not entirely, it's not clear to me that the findings, in my opinion, weren't a model of clarity. I think it's reasonable to draw that conclusion that the judge grossed up the thrift savings plan in some respects, but that seems to segue into an argument that my sister was making, and that it was a double dip, and I don't believe that it was.
Well, I'm reading the judge's findings after reading the 2 briefs, and I get to page 18, and you know, it's page 17 and 18, it seems clear to me the TSP had a value of 1.247 as of April 3rd. Wife withdrew an additional amount of $250,000. Given the fact that the wife's having withdrawn $250 to invest in Stepstone caused an approximate loss of $50, coupled with the fact that the court has not backed out premarital assets, the court finds that for purposes of dividing the assets, the value of the TSP is set at 1.247 million. Judge knew that it wasn't 1.247. He gave your client half of 1.247, right?
Well, that finding is at odds with the wife's testimony at trial. She made it clear that
whether it's at odds with the wife's testimony or not, these are the findings of the judge. The judge knew that they weren't, that the judge knew he was not splitting that $1.247 million. And then he also added $200,000 to the wife's side as on the promissory note. Why isn't that?
That wouldn't be sufficient, Your Honor, in my opinion, for the value in and of itself of the FERS pension, because that it was completely.
Okay, you've jumped right to.
Well, I'm not trying.
No, I'm not complaining about it. I understand what you've done, but is it? And what is wrong with my notion on reading this that there was sort of rough justice done here, that the judge did not split the actual assets 50-50, but left more of those assets with your client, but then left the wife with the entire value of the pension?
Okay. Even assuming the judge understood that the thrift savings plan had a lower value because of the withdrawal of the $250,000, that would get the value down to a number in the 900s. But when the
1 million even.
When you're dividing, you're right. When you're dividing the assets in this manner, the value that my client gained is half of the 250, and that number doesn't sufficiently, and under the Casey decision, doesn't provide sufficient consideration for excluding
Then there's the 200
the
that
pension.
the 200 the judge also put in, so the judge did double count it.
I don't think the judge did double count. I understand in.
So now we're at 300.
Wait, I don't understand. This thing you put on page 15 showing about 50-50, it's based on the thrift plan being worth $1.2 million, and we know it was worth about $1 million, and it also has the $200,000 promissory note. So only by including the promissory note and having the thrift plan at more than it actually was do you get to your 50.15%.
That's right.
So the judge didn't give, even by, on your calculations at least, the judge gave your client more. Not unfairly, but more.
Well, I guess I can't separate the TSP from the pension. And while, as I said.
Can't you separate the TSP from the pension? They're totally different things.
Except that when you look at the Section 34 division as a whole, when you're excluding the pension in pay status, there has to be some consideration.
Sorry, I get it now.
Okay, and so even assuming, and I'm not assuming that, even assuming that the judge was incorrect in calculating the value of the TSP that he included at 1.247, and then on top of that added the 250, that is consistent with what the wife testified to in terms of value. So it wasn't a double count, and my client got the value that the wife claimed it was worth when the case went to trial. It was worth 1,247 after I withdrew the 250, which the judge did give at least partial consideration.
Well, no, the judge found that it was at that number on April 3rd, which is before the withdrawal of 250.
Except that the wife admitted that it was after the 250.
Well,
That's an argument of clear error.
The testimony was, well, the number you put in on here, on the corrected one, is 1,247,211,29. Is that correct? Yes, that's correct. And that's wrong too? No, that's correct. I mean, so I don't see why the judge couldn't credit that and credit the financial statement.
Well, the judge did, obviously, in terms of a credibility finding. I understand that's a tall mountain to climb. But I guess I keep coming back, and I apologize, but I can't ignore the fact that even assuming the judge made clear error or the judge, in fact, sought to compensate my client for what he did with the TSP, vis-a-vis all those withdrawals, the pension itself just can't be sloughed away and fall under some sort of consideration for the pension itself. The value was between roughly $900,000 and $2.2 million.
What is the difference? Can you just help me with the expert? Why are the experts so far apart?
The wife's expert used a 3-year aggregate of income, which was about 5 years earlier, and therefore, when her income was lower. The husband's
It was just wrong, right?
well, it's not wrong, given the years that the expert relied on.
Yeah, but why would the expert rely on that when she didn't retire until 2021?
I would agree with that. And the husband's expert used a more current aggregate of income, but the judge made no findings on that, given how he treated the pension. And I think...
So is the value, the $2.3 million that your expert put on it, is that based on the income stream beginning in July of 2021, or beginning December 2021?
It's the last 3 years of her income.
Right, but it's the income stream into the future, right? It's a reduced
Yeah.
present value.
Right, exactly.
Okay.
So,
An assumed lifespan.
yes, according to actuarial tables and whatnot. So when the judges, and in this case, you have the wife retiring on the eve of trial without notice to anyone. And the upshot of what happened is she converted this valuable asset, had she remained employed, into an income stream, which the judge then effectively, well, not effectively, awarded to her at 100%. And seems to have linked it to A, the fact that it was an income stream, B, the fact that he didn't back out the premarital assets in this case, which doesn't make a lot of sense, respectfully, when my client brought 4 times the amount of assets into the marriage.
Not exactly, right? Because that income stream that you're valuing at $2.3 million, the wife had already invested 15 years before the marriage into developing that income stream, right? Because she had to have a certain number of years in before she could access it as an income stream.
Well, that's true, but...
How many years did she have to have in under federal law before she could access it as an income stream?
I honestly don't know the answer to that. She had 30 years in when she did retire.
15 before she got married.
But the judge, I mean, the reality is...
I know, it's not in the papers, but the
judge isn't required to somehow credit either party for the premarital assets in this case. And if he treated that, or if he somehow considered that, it's not apparent from his findings at all.
But it's a fact. It's a fact. You say it's worth $2.3 million. Half of that time she had put in before she entered the marriage. That's a fact.
It may be a fact, but cases are clear that however and whenever acquired, it's all in at the time of the divorce. And that's what, and in this case, the judge went past that, looked right past that. And I don't think, Judge, even under that approach, say the judge somehow carved out the distinction between premarital and postmarital pension interests, my client got nothing for that. And it's just simply not apparent from his findings. I mean, he did justify it. He justified it on this premarital asset concept and under the fact that it was an income stream. But I don't think that's sufficient given the potential value that it represented in this case. Now, there are 2 other issues. There's maybe one other issue. Okay.
Let me move on to another issue. I had a lot of trouble following these tax returns that your client prepared. Now, if you can't help me, that's fine. But I do have some questions.
Which tax returns are you referring to, Judge?
He did these pro forma tax returns to show that it would be better to file separately.
Yeah, okay, yeah.
And I mean, I couldn't understand why on his 2555, he claims to be a bona fide resident of Poland through the end of 2020. I just couldn't understand that, since the facts findings here are that he moved to the U.S. when the pandemic started and was never going to come back.
Judge, I'll be honest with you, I can't answer that.
I mean, you're not expected to be a tax expert. If you understood them, I wanted to talk to you, but if you don't understand,
Well, I don't know. I mean,
it's fine.
Off the top of my head, I'm not familiar with that. I mean, I do know that for the bulk of the marriage, or not for the bulk of the marriage, for the bulk of the years leading up to the divorce, he was a resident of Poland. He wasn't filing Massachusetts tax returns at that time, and, you know, as a consequence of that, how that jives with his pro forma financial tax returns, which I assume were the ones you're referring to, the motion to amend, I honestly don't know the answer.
I mean, it's entirely based on the foreign earned income tax worksheet, which we don't get into. Anyhow, it doesn't, I don't know.
apologize. You caught me off guard.
Not expected to be a tax expert. This is not a tax case, but if you knew.
Ditkoff is.
Can I ask a technical question? I'll see if my colleagues have any questions. You filed a motion to file a supplemental appendix at the same time you filed your reply brief. And you also had a bunch of documents in your reply brief in the back. Are those the documents, or are there other documents you want us to see?
Well, the issue that I was trying to address was the proposals, which were not included in my initial appendix. And it's because there was, you know, the arguments raised by counsel in her appellee's brief. And I did try and come to an agreement on the contents of the appendix, as I pointed out. Counsel was not involved in the case at that time. A predecessor counsel was. And I never heard one way or the other, which is why I proceeded as I did.
Yeah, no, all I'm trying to understand is, if we consider the issue, the documents you've put in the back of your reply brief, have we considered what you wanted us to see? Or are there other documents that you wanted
No.
to give us? Those are the documents?
Yeah,
All right, so
as referenced in that motion.
So if we allow those documents, we don't need to file anything. You don't have anything else you want to show?
I don't.
Okay.
I
I think there might be more
There are.
questions.
Yeah, I have a question about your third issue. So, did you raise with the judge that you did not want, did you raise with the judge below that you did not want to file a joint tax return?
In the trial court, the proposals that my client filed requested or suggested a single individual filing. The wife did not address the tax filing at all.
Okay, so then the judge orders us
A joint return.
And did you seek to amend the judgment on that issue?
That is true, yes.
Okay, and the judge denied that?
He did, without
Okay.
any comment.
So there's a request to amend the judgment. Okay, now, is there case law that I should be looking at that will say judge can't force somebody to file a joint tax return?
I do allude to that in a footnote in my reply brief.
Yeah, I saw that.
Under the tax code. You know, the Fector case says the judge, you know, can address these tax issues, and I've certainly seen trial judges order parties to file joint returns. But in my view, that's inconsistent with the code. It's inconsistent with forcing someone to file an affidavit, frankly, and that's essentially what happens here. You're forcing someone to do that, and then putting them, you know, individually liable or joint and severally liable for whatever consequences may flow from that filing. The judge can address that separately without.
Did you make the argument below, Judge, as a matter of law, you are precluded from, you did not?
No, because he just requested an individual filing. And so the issue.
No, but this is important.
Okay.
Because I need to understand what you argued to the judge below on this point, because there's a legal issue buried here, which you've now surfaced, which is, as a matter of law, can a judge issue this order? And as I understand it, when you sought the amendment to the judgment, you did not say, Judge, as a matter of law, you can't do this. Okay. Thank you.
All right. Thank you very much.
Yeah.
We'll hear from counsel for the wife now. Whenever you're ready, Counselor.
Members of the panel, may it please the court. My name is Joanna Gibson, and I represent the appellee SHERRYANN QUINDLEY. Before your honors are three issues. The first is the appropriateness of the trial court's decision to treat the wife's federal pension as a stream of income, the appropriateness of finding the wife in contempt, and the appropriateness of having the parties file joint tax returns for 2020. As this court has found, the appropriateness of treating a pension as a stream of income, there must be a review of the whole award before there must be compensation.
You agree with your colleague that the wife was assigned the complete value, 100% of the value of the pension?
Yes, she was.
Okay. And the record shows that value could be as much as $2.3 million, right?
That's correct, Your Honor.
Okay. So how do you justify that?
Your Honor, the pension was in pay status. And just to go back to one of the questions that you asked my brother about the differences in the values that both pensions or the experts provided. The reason for that is there was a discovery issue. The discovery was closed. The experts were provided to the court, and the pension was to be determined based on whatever discovery was at that time. Off the top of my head, I do not know when discovery closed, but it was due to discovery closure. At the time of trial...
My understanding is that you did not issue an expert report on this issue until the day of trial, when you showed up with an expert report for the first time. Is that accurate?
Yes, I believe so.
Okay, so why are we talking about what happened during discovery when you didn't even follow the rules, or your predecessor didn't?
No, I understand that, but during the pretrial, there was each party proposed the expert. Each party proposed that the pension would be valued as a certain date based on the documents that each party had. And therefore, by the time that we had gotten to trial, discovery had been closed for a while. And there was issues.
Right on. I mean, this argument is hitting me really wrong, because I've been in situations where someone has walked into trial and handed me an expert report and the judge has allowed it to go in, and I've always thought that was wrong. But now it seems like you're doing two things. You're saying, yeah, even though we did that, we're going to justify this expert report that wasn't based on what the facts were on the ground because of discovery limitations. I mean, your colleague has represented to us that the difference between the values is that his expert's report was based on the more recent income information from the wife that would be the actual income information that would be used to determine what her pay stream was starting in December of 2021, and that your expert report was based on data from years before. Is that accurate?
That's my
Okay.
understanding, Your Honor.
All right.
So, while I understand that there has to be a compensation, and there was compensation, because we are not only just treating the award of the assets, we have to look at also the alimony, because we have to look at those together. And once we look at the fact that there was no alimony, that the husband was awarded 25% of the survivor benefits, that an actual correct calculation of the husband's income, this combination in and of itself results in an equitable award toward the husband.
I mean, that would make sense, but we don't have findings to support that. That might have been what the judge was saying, but I don't see any findings saying I would have issued alimony except for this pension, or even what he deemed your client's real income to be, because he certainly didn't believe that she was incapable of working. So how do we get there as an appellate court? You might get there on remand, but how do we get there as an appellate court?
So the court did say the court found the pension is the wife's only source of income. The court found did not attribute any income. The court said that the parties are waiting, or the husband and the wife are waiting to explore further employment or opportunities to proceed or obtain a further income. I think that by saying that there was findings saying that the wife has had significant health issues, that the wife needed to withdraw funds from the TSP. I think that all those
Both
things
parties
together
are in good
reasons-
position to acquire future income through their respective skill sets.
Right.
So the judge seems to be saying that your client will make money in the future.
Right, but he went as far as saying that, but did not attribute any income, which he was in his right to do. I think that was argument that was made by.
But didn't he just wash his hands of that problem in the sense that he just sort of said, look, they both parties in front of me are educated, have skill sets, they're going to be able to make money. I think he made a point of saying that your client said that she needed a year to recover from what she'd been through, but it was more than a year as of the time that he entered his order.
Yes, that's correct, Your Honor.
The implication being, okay, based on her own testimony, she should be ready to work.
Yes, that's correct, Your Honor. But not only is it the review, if we take the whole award as a whole, and you've asked me, Your Honor, what findings? I mean, there are plenty of findings that we can infer that the husband is being compensated for the exclusion of the exclusion of the pension is a stream of income, and the judge has the discretion to do that. And there is, like I've said, there is reasons why, once we take the whole case and determine that there was a disproportionate division towards the husband.
Do you have specific references or citations to the opinion? Because I understand common sense. If alimony is not awarded, then you look to see, well, did everything kind of match up, right? Does it seem fair and equitable in a distribution? And was this an oversight? It would be great if the fact say, I am not awarding alimony because I have made these other kind of decision points to create an equitable distribution of the marital property.
I think,
where do I infer that when I'm reading this? Like, tell me where I'm inferring that this is what the judge meant, and it's clear that the judge meant to do this.
I think, Your Honors, when we take all of the findings together, so we start off with the pension is her only source of income, the pension is her only income, that the husband can earn, that the husband just a month before trial was earning up to $30,000, that she gets the $200,000 note, so that shows the disproportionate of the assets. So taking all of these factors together with with how the parties acted or how they were during the marriage, I think that it can be inferred, and that there was a payment, and there was a disproportionate share to the husband. There isn't an equation, there isn't an exact math as to he should get this, and then that's how we can keep it out. I think that taking everything together, the husband's ability to earn, and the husband's ability to earn, the fact that he did get a disproportionate share of the TSP, that survivor benefit, although he says that it's so far removed that it shouldn't be an asset, that is an asset. The fact that he's able to get health insurance under the first payment, that he didn't even
I assume no one tried to provide an expert opinion on the value of the survivorship benefit?
I don't believe so, Your Honor. I don't.
Can I ask you about the $482,000 in withdrawals?
Yes,
So
Your Honor.
the 250, I'm clear on. I understand where it went. I understand how it was treated, and I'm fine with that. But what about the $232,000 that the wife withdrew between November 4th and February 9th, November 4th, 2020, and February 9th, 2021? There aren't any findings as to how that was used, are there?
I believe there is definitely testimony, Your Honor. There was testimony that she
Are there any findings?
No, all the findings that are in the judge said was that the withdrawals from the wife, from the TSB account, were for reasonable and necessary expenses for her pay for her everyday expenses.
But it's $232,000 in a 3-month period when she was earning $135,000 a year. I don't understand.
So by that time, she had stopped working. So she retired in July of
So she had no income for 6 months?
6 months, Your Honor, yes. So
And
she
the
was
first
paying-
withdrawal was toward the end of those 6 months, is that right?
I believe so, Your Honor.
And it equaled roughly her annual salary for a year?
I believe, yes, I believe so, Your Honor. I think that the expenses that she was trying to pay was any, the tax, I'm sorry, the payments of her credit cards for paying for everyday expenses. She needed to obtain, I think there was a issue with her car. There was attorney's fees that she had to pay. There had to be payment of
Attorney's fees.
experts.
But she had $250,000 sitting aside from her lawsuit that she used to pay attorney's fee. Okay.
The attor-
I'd missed that. Okay.
Attorney's fees.
Yeah. Okay. All right. I didn't have anything more than that.
Sorry. If I may, just on the contempt issue, there was the husband had the burden to show a clear and unequivocal command and a clear and unequivocal disobedience. In his amendment complaint for contempt, he claims that the wife violated the automatic restraining order by withdrawing funds from the HELOC account as well as the TSP. The HELOC account, all she did there was just conduct a rotation of the shifting of funds. They had withdrawn from the TSP account. They took out a loan to pay in October 4th of 2018 to pay for improvements of the home. They both knew that this needed to be paid by November 14th of 2020, otherwise the parties would incur a $10,000 liability.
But that's a $27,000 item, right?
Right, so that was part
But
of
she
the
took out
withdrawal.
100,000, 120,000.
Right, so in addition to paying those,
What did she report as her attorney's fees? $500,000 before trial?
I don't know that off the top of my head. I believe it's on the financial statement, Your Honor.
Okay.
On a different note, did your client express any position as to whether a joint filing of taxes would be something that she would be agreeable to?
She would be agreeable to file a joint tax returns. I think that is what they were discussing during the motion to alter or amend. Before the case went to trial, the parties did discuss the issues of the case, and one of the issues was the taxes, or whether or not they needed to file those together, They submitted that, and at trial, neither party had filed tax returns for 2020 because I believe that there was the federal extension where people were allowed to file a bit later.
Do you know what the set?
Wasn't
Sorry.
clear. But did your client express a position?
I don't believe so, Your Honor. I just think that the issue of taxes was just left open on that, issues for the judge.
Do you know whether it's been filed now?
I believe so. I believe it has been filed.
Do you know whether it was filed jointly or separately?
I believe it had to be filed, married filing separate because of the filing of the husband after the trial took
Okay.
place.
Obviously, it can be amended to joint. Obviously, it can be amended to joint at any time.
I'm sorry, say,
Obviously, it can be amended
Oh,
to
yes, of
joint. You
course,
can't
yes, it
amend the
can.
other way.
of course, yes, it can. And finally, just quickly on the tax issue, on whether or not the parties, like I said, did bring this issue before the court. The court was well within its discretion to deal with the tax issue. And just as a quick on that, the parties filed joint tax returns for 2019. They received a $19,000 credit, of which $5,000 was allocated for the 2020 anticipated taxes for 2020. So it would be unfair for the husband to be the solely beneficiary of that benefit. If there are no more questions, I will, I'm sorry.
I'm chuckling because the husband says on the other side of it that there's a $50,000 tax benefit, or probably more, for the money that the wife withdrew from the TSP that he's paying half of, right?
No, I understand that, but this was all filed after the fact. He had provided in court that he had not yet filed tax returns, and those were anticipated tax returns. We don't know what There's issues, just like Your Honor mentioned. He says he was living in Poland the whole year, where he had left and been back in the United States as of March of 2020.
All right. Well, thank you very much. It's a very complicated case. Ms. Gibson, I hope we'll see you more in this court. And I know, Mr. Derlin, we will see you many times. You're a frequent litigant here, so thank you both.
Thank you, Your Honor.
All right. With that, I will call the last case of the day, number 23P 369, Friedman versus the Division of Administrative Law Appeals. Mr. Friedman, whenever you're ready.
Good morning, Your Honors. If it may please the court, my name is Bruce Friedman. I am a plaintiff and appellant in this case. I'm a citizen journalist, a data science enthusiast, and a principal infrastructure architect with a career spanning 31 years in information technology at the very highest technical levels, including positions at some of the Commonwealth's most recognized institutions. I'm a parent who actively advocates for my high-needs child who has differing abilities, and this advocacy has led me to meet with similarly situated families. I've sought public records and data about the Commonwealth's special education systems. I have analyzed and published this data and reported on the efficacy and lack of efficacy of systems in place for our highest need students like mine. For example, one of the requests in count 3 was related to determining the veracity of certain statistical information published by the BSEA publicly.
Which one of those, of the count 3 ones?
That's in...
No, which one? There's like 3 different April 26 ones. I'm not sure which one you're talking about right now.
The one is for the data.
So what is the actual request?
For
All data from what time period to what time period that resides
all
in?
the data that was used to produce the public statistics that they published. And those
Is that what is that the actual request?
It is, and copies of the actual screenshots.
No, it didn't say what you just said.
Yeah.
It said something different. And part of the difficulty here is I couldn't find specifically those 3 requests. They're referenced in the Attorney General's brief, but I couldn't find them in the complaint. So I guess do I need to page through and find the actual request?
I think the requests are published in the exhibits attached to the complaint.
Okay, so this is the one for all data. What did it say and what exhibit is it?
Or even better would be the cite in the volume, the appendix. Because I had the same trouble. I saw it mentioned in passing in the Supervisor of Public Records responses, quoting parts of it, but I couldn't find those 3 themselves. Where your October 2021 and your May 2022 requests, were definitely in there.
And are actually set forth in your complaint.
Yeah.
I don't see them there. I can't tell you with 100% confidence that they were included in the exact same way that the other ones were.
What do you think it said?
There were 3 specific requests. One request was for all of the electronic calendar information for the director.
That's not this one.
The second one was for each of the pieces that had been published in the statistical information of the BSEA on their public website, which were in 3 cases where a parent was a self-represented or a pro se litigant. 2 of the cases were they were successful, and in one of the cases had a split decision.
You were asking for the records?
The data that the BSEA used to compile those statistics.
So,
And I gave an example of each one of the indices that they did, including an Excel spreadsheet that had the tallies for each year, and the numbers changed.
For how many years?
2013 through 2019 was what was published at that point in time.
So you asked for, see,
it's problematic because what I found in the SPR is this: any and all raw data in any format, including but not limited to databases, spreadsheets, recordings, electronic mail systems, and/or written documents which support, detail, or produce substantive data published in the attached published documents for the following specific information. All documents substantiating the number of hearings requests filed by parents, all documents substantiating the number of hearing requests filed by school districts, and it goes on for a while. And I don't know how a records access officer could possibly respond to that, because it would require information outside of the documents.
Well, if you finish the reading that you're doing there, Your Honor, you will find that it goes back to talking about how it substantiated the statistics that were there. In other words,
Well, not in what we've been given.
okay, the record may be incomplete. I apologize for that. We believe that the BSEA did not go back and gather statistical data. These were contemporaneous notes that were kept by the director, and this is how they ended up publishing those statistics.
when we're saying those statistics, what are you talking about?
On the BSEA's website, every year they publish statistics about the caseload, about the success rate of represented and unrepresented parties. They post a series of annual reports that are statistically driven, and they give specific numbers. Again, they will say there were 854 IEPs.
Your view is this request was for all the data that was used to create the reports that are on the website from 2013 to 2019.
Correct.
See, that is the kind of request that someone could respond to, you know.
I think you picked the most troublesome request, Your Honor. I agree with you.
Like a request, you know, here's some stuff on your website. What's the support for it? What documents supported it? I mean, that's something that a records access officer could say, okay, figure that out. Talk to the person who made the thing. Give me the documents that you used to get that.
I understand your point, Your Honor.
But this is the problem. This is why we have a Superior Court judge who essentially said, start over. He said, more than essentially, that is exactly what he said. It's because if there were actual communication in good faith between both parties to try to figure out what it is you really want and need, then the process will work.
I agree with...
But if instead, every time that there's any response, you go to the SPR and you say, I'm unhappy with the response, then you create a situation where a lot of wheels are being spun and time is being spent. And it's government time that, under the statute, you have to pay for, unless they don't respond timely. But boy, when you're getting one after another, plus an SPR after an SPR after an SPR, and you only have 10 employees, it starts to look, and I'm going to use a word here, unreasonable.
I understand your point, Your Honor, and I will drive you back to the very first request, which was not responded to in 30 days. There were a myriad of excuses. I tried to communicate with Chief Justice McGrath at that point multiple times, very unsuccessfully. That's when I started to engage the SPR. And the SPR, if you go back and look at the diatribe of SPR decisions, they do not rule against me. They do not tell me that I'm wrong. They consistently rule that they have not answered the questions correctly. And at some point in time, when they promised to give the records, as in the first request, and they repeatedly promised to give the records, and they repeatedly promised to do that, and to this date have not provided one substantial record above what was provided in December of 2021.
That's just directly contrary to what they say, which I have difficulty with in terms of...
Motion to dismiss.
Well, that too, yes. But it starts to get to the point where, you know, it's like sometimes we have lawyers in here, and they'll say, this happened and that happened. And you're like, were you guys standing at the same trial? Did you, like, I mean, they say they have produced documents to you with respect to certain of these requests. Are they just not telling the truth?
Yes, Your Honor. And I think you've uncovered one of the biggest problems in the public records environment we have today, is that the same records request that we're talking about was quoted at $13 million. The Secretary of Public Records challenged the veracity of that quote, and it was reduced by 99.5%. We find regularly that public records officers and holders overstate the number of records on purpose to thwart the records attempts.
This is simple. It's like, did we get documents? For example, there is a request with respect to, which you identified earlier, there is a request with respect to the calendars of the director.
Correct.
They say they have responded to that. You have received documents. Is that not true?
That is not true.
I thought they said there was no such documents that they possessed.
And the supervisor of public records asked them to go back and check, and they verified that there was no electronic record, and they have never provided it. They asked her to look in her electronic outlook, if you will, and there was indeed an electronic calendar, and they have never provided it. And again, back to the first original request, they have released 4 series, which we have all documented. And there are 493 documents of 11,000 they identified. They have not provided all those documents.
Right, and that was a good request. I mean, that was specific
yeah.
email domain. I mean, that's something that someone could search for
Correct.
and find.
And we have a subsequent request in with the Executive Office of Technology Services and Security, who actually fulfills all these requests for these independent agencies. They're the IT department, if you will, for the state. And they have decided to fight that request, and we are actually in litigation in the Superior Court in Suffolk County on that particular issue and have a hearing in November. There will be proof of how many records they actually provided and what search they actually did on behalf of the BSEA in this case.
So, for the May request, I'm reading from the brief because I want, it's just hard to piece your way through. For the May request, so the May request was for all documents between Murphy, Hesse, Toomey, and Lehane for like a 9-year period, right?
No, it was a 2.5-year period, Your Honor.
The May request, no, I'm sorry, it was a 5-year period.
Should have been from 2018 until the time that the request was answered, and the request was made in 2021.
The exhibits attached to complaint incorporated, I'm reading again, informed Mr. Friedman they had provided all non-exempt responsive records. This asks for text messages, right?
That's the second request.
That's the one I'm asking about. The May request is the second request. It asks for text messages. They say they've produced them all.
I have a witness that I can bring to court that will tell you that they have a text message in their possession that is not included in that is responsive.
Did they produce some?
They did produce some.
Okay, then I don't understand. You just represented that they didn't produce anything beyond the first set of documents, which I think was in response to the first request.
No, the first request was for emails. The second request was for text messages.
Yes.
They did produce some text messages. They only produced text messages from the BSEA director.
Are you making a distinction when you say they've only produced documents, 436 documents, text messages aren't documents? Is that the distinction you're drawing?
436 records were produced of 11,000 emails.
Okay.
That's for
but
request
they
one.
produced text messages.
For request 2, they produced some text messages, and they withheld all the text messages between the BSEA hearing officers and Murphy, Hess, Toomey, and Lehane. And the reason that they did that is because they said that that public business was done on private cell phones, and they had no ability to get a hold of it. This is an end run around public records law, and it's happening at the DCF, which has now changed their policies because of these requests, where people are using they're doing public business on private cell phones to avoid the scrutiny of public records, Your Honor.
All right, so let's try it this way. The October request, you received some documents, but you're quite certain there's more.
Yes, and they have said that
And-
there is more
and
and
the-
that they would release them.
The May 2022 request, you've received some documents, but you, for the reasons you just explained, are certain there's more.
Correct.
And then for the case management system used by BSCA, have you received any documents in response to that?
I have not.
And the calendaring documents,
I have not.
they responded, there was nothing, and you don't believe that?
No, they responded,
You
there
haven't
was
got
nothing to the supervisor of public records, who found that they needed to go back and look, and then they said that they had indeed found an electronic calendar and that they would provide it, and they have not.
And in the website one, you haven't received anything?
Correct, and I didn't pay the bill. I wanted the court to review the feasibility of the bill that they had put forward, which had already been reduced by 99%.
Okay.
So, getting back to the decision, and, I mean, I understand in part why you're here, but there's got to be some sort of balancing, right, of the burden, as Justice Englander spoke about, a government entity with a small number of people kind of responding to a number of requests versus the public's right to information. And it seemed to me, and maybe it's not the perfect world, but what the judge was hinting at was just need to be in the reasonable zone here, right? If you're looking in plain English to find out what they relied upon to get to this graph, to get to this statistic, get to when they posted on their website, just ask them that, and they might be able to get there. I understand your frustration. I think I can understand the other side's frustration, but at the end of the day, this system only works if there are two reasonable parties, right? One that may not really want to give up and dig for the information, and one that might want a whole bunch of information. But it seemed to me, but what was missing, that the judge tried to get the point across, was we got to add reasonableness.
I understand your point, Your Honor. I do think that that does bypass the problem of overstating records quantities for the purposes of thwarting requests. And it is a constant. My organization has paid almost $10,000 to multiple agencies to produce records that all overestimated their records by about 90%. So we paid, and then 2,100 records turned into 27 records. 3,000 records turned into 105 records. This is a constant state of affairs because there is no enforcement mechanism. The only enforcement mechanism is the one that I'm in the middle of with you all right now. The Secretary of Public Records has no teeth. They have no legal authority to compel anything. The only thing they can do is refer to the Attorney General, who takes up very few cases, and in the case that they do, they're following the exact same path that I'm taking with you today. So I think that integrity and honor is another piece that is identifiable as missing from this process, and there is certainly the belief at this point and some indicators that the Attorney General's office has provided information to records access officers in ways to subvert public records access. And I think that there is the faith in this system is based upon our ability to trust but verify. And the ability to verify is villainous in some of these cases. And some of these agencies are in trouble.
You're quite a bit over. Let's just further questions.
I do, I'm sorry. I
sorry.
apologize for this.
No,
It's just really
please, go
hard
ahead.
to. So the first request, October 6th, all electronic mail or text messages between BSEA and anyone at mhltl.com email domain for 2.5 years, right?
Correct.
They say there are 11,000 of those documents.
Yes.
And here's the first tranche, because we've divided it into 15 tranches, or whatever it is. It's going to take one person, I forget what it was, I figured it out, like 10 days for each of the tranches for one person. It's like several 40-hour work weeks. What happened to that?
They They agreed to release the records multiple times on multiple rolling schedules and never met one of those dates for one more record. Not one more record has been released since December of 2021.
Do you think it's reasonable to ask them to produce 11,000 records, which may or may not include information, right? I mean, one of the problems here is you're asking for information that they have to read every single document because it involves individuals who are dealing with the government who have their own protected statutory rights, right?
I believe that there may be some exemptable material in some of those, but I think the 11,000 number is incorrect.
Some exemptable material?
Yes.
As I understand it, MHTL represents the agencies who are dealing with people who are presenting legal claims on the basis of people with special needs. Is that right?
MHTL generally represents school districts in
Right.
front of the BSEA.
Okay,
correct.
so most of what we're going to get are communications with respect to particular individuals about their special needs.
No. What you should be getting is procedural documents, much like the things that are filed in this court that are public record. There should be very little in there that falls under IDEA or FERPA. There should be nothing that falls in under attorney-client privilege. The amount of privileged documents that go through there actually should be zero if they're doing it correctly, because everybody whose name is in there should be redacted.
So let me make sure I understand. The agency is the agency that adjudicates these concerns?
Correct.
But you'd have to redact. You just said you have to redact the names. Every one of these documents needs a redaction.
No, I think the vast majority of them should have no redactions.
Why don't the names need to be redacted?
I'm sorry?
Why don't the names of the parties need to be redacted?
They should already be put into a format on the filing where they're using a pseudonym. They should never be referring to the actual.
Is that what happens?
Yes, in many cases, yes. Yes, there are lots of public filings that are available from the BSEA, including decisions that handle this all day, every day.
I mean, we use pseudonyms, but on our system, we have the actual names.
These would be communications between the lawyers who represent the school districts and the party that adjudicates those. So they should be handled as, they're not impounded, they should be handled as public documents. And that is their own policy.
Thank you.
And there would be no attorney-client privilege between the private attorneys for the school districts and the BSEA.
All right, thank you. We'll hear from the Commonwealth. Whenever you're ready.
May it please the Court. Good afternoon, Your Honors. Assistant Attorney General Christine Feminari on behalf of the appellees, the Division of Administrative Law Appeals, and the Bureau of Special Education Appeals. We ask the Court to affirm the decision of the Superior Court below for the following three reasons. First, the Superior Court properly found that the requests at issue in this case were not reasonably described and thus did not trigger the requirements of the Public Records Law time limits. Second, and in the alternative, even if the court is not persuaded that the requests were not reasonably described, we did argue alternative grounds for dismissal below, which we believe the court can affirm on, that those were mootness and failure to pay the fee. And third, Your Honors, we would ask the court to find that the Superior Court's order requiring the requester to confer with the agency about the reasonable scope of the request before he seeks further judicial intervention was appropriate, and affirm that.
So let's take the first request we were just talking about.
Yes, Your Honor.
October, they asked for all communications with MHTL for a 2.5-year period.
Yes, Your Honor.
Your contention is, Commonwealth's contention is that's unreasonable as a matter of law.
Yes, Your Honor.
Why?
Because, Your Honor, it produced, the search that Mr. Friedman made resulted in over 11,000 documents that the agency has to go through and determine whether redactions have to be made. The public records law requires that a request be reasonably described, and the regulations to the public records law clarify that a reasonable description is one that allows the agency to promptly identify and locate the records. Here, Your Honors.
Right, so why doesn't that allow you to identify and locate the documents promptly? It's just a computer search. I understand it'll get you a lot of documents, but...
Yes, Your Honor. So it's a computer search, and then it has to be reviewed for responsiveness, and it has to be reviewed for redactions. So it can't be produced promptly.
Nothing requires it to be produced promptly. It just has to be identified and located promptly from the description.
That's correct, Your Honor, but we'd ask the court to look to the David Project case, which is a Superior Court decision in which the court considered public records requests that sought all of certain records that reflected or constituted certain information. And the judge there said, you know, this...
Yeah, well, reflect is a terrible thing to say in a public records request, because how is a record access officer supposed to know what reflects? I mean, and you're trying to get into the brain. But this first request, it's very specific. It's whatever has this, you know, at mhtl.com. I mean, it's almost designed to be able to run it into a computer.
We don't dispute, Your Honor, that you could identify the records that exist for the at MHTL email domain. What we dispute is that the agency can reasonably review and produce 11,000 documents within 10 or 25 days under the public records laws time periods.
If you ran the search and it came out with 100 files or documents, your argument to us would be like, that request was fine, that meets everything, and we can do this.
Yes, Your Honor. I think when observing whether a request is reasonably described, the SJC noted in the Globe newspaper Company versus Commissioner of Education case that there could be a record request that could not be met within a 10-day time frame, and in such circumstances, the statute would require the custodian to show that release was not possible given the magnitude or difficulty of the request. So we do believe that the SJC has indicated that the agency can consider the magnitude of the request.
And how long you take to fill it, but not in whether you do it at all.
Yes, Your Honor, and the agency has never said that they would not do it at all. The agency responded.
No, I get that, but the judge ruled this request is no good as a matter of law because it doesn't reasonably describe it, and so no one ever has to comply with this request.
No, Your Honor, the complaint was dismissed without prejudice, and all the judge ordered was that the requester has to confer about certain topics in good faith with the agency before he can either amend his complaint or file a new complaint.
That's your third argument. Your first argument was that they were not reasonably described.
Yes, Your Honor.
Right. You said to me in response to my question, as a matter of law, the judge could determine that it was unreasonable as a matter of law and could be dismissed on that basis. That's the Commonwealth's position, right?
Yes, Your Honor.
In which case, no one would ever have to comply with it.
Yes, Your Honor, but that's not what the court ordered.
Well, the court dismissed it and said, normally when you get dismissed without prejudice, you can file the same thing tomorrow. This is a dismissal without prejudice where you have to jump through some hoops before you can even apply it. So it's even worse than a dismissal without prejudice.
I don't know if I would describe it as worse, Your Honor. It addresses the concern that there's
worse for Mr. Freedman.
But, you know, when you look at the dynamics of power and who has kind of the goods, right? And so you got a citizen who wants to unearth what they relied upon. It's a shot in the dark, right? I mean, they're asking for a bunch of things because they don't know what they don't know. So there's some degree of the request starts out bigger because they don't have the documents themselves. They have to have you look through them and then redact and review. And so the sheer volume doesn't seem to me to be, at least in my initial view, to be the winning argument.
Well, in this case, Your Honor, the agency offered repeatedly to work with Mr. Friedman to modify the scope of the request, to find a reasonable scope, to get to the documents of what he needed. After they produced the first batch, they asked him to review the first batch and to see if he could change the scope of his request. The supervisor of public records noted in some of her opinions that she would encourage the parties to communicate with each other and figure out what it is that the requester actually is after. But Mr. Friedman has refused to do that. He simply appeals every response that the agency provides to the supervisor. So yes, Your Honor, there certainly could be instances where a requester submits a request, doesn't know there's 11,000 documents, and, you know, has to adjust that scope because they simply don't know.
Was the first tranche 1/15 of what had to be done?
I'm sorry, Your Honor, could you repeat that?
First tranche was 1/15 of what had to be done?
I believe it was 484 documents, Your Honor.
Right, but was it 1/15 of what they thought they had to look at?
I would have to do the math. It's 484 out of 11,000.
Well, see, that's where I'm having difficulty, because I thought I saw the word 15, and I'm multiplying 15 times 400, and I'm getting 6,000. And this is his point, which is everything is always overstated. And I mean, maybe 11,000, 6,000, not so much, but I'm trying to understand the burden, the real burden. So one of the questions I had for you is, you say, I have to review all 11,000 hits. What are you reviewing for when it's basically filings made public? I mean, they're public filings in any event, aren't they? I mean, they're filings made to an adjudicatory body.
Not necessarily, Your Honor. It's all emails between the BSEA and anyone at the @mhtl.com email domain. So those are lawyers and the adjudicative agency, and there are individual parents and students' names and special education records, and there are multiple statutory requirements to redact things like parents and students' names and special education information. And the agency, from the start, has identified those statutory requirements.
Okay, so you guys, from the perspective of the public, I'm sorry, from the perspective of the public agency, then they're saying, look, he's asked for 11,000 documents. We've looked at a few of them. We know that we have to look at every one carefully because there are other statutes that tell us we have to redact things.
Yes, Your Honor, there's an
So,
obligation.
in your view, the way this should work is either A, the judge does what he did and says it's just unreasonable, or let's get past that one. It's B, we then say, this is going to take X man hours at $25 an hour. You need to pay us that in advance.
Yes, Your Honor.
Am I right? Those are really the two alternatives. One, you either win outright because it's unreasonable, or two, you have to do it. You have to look through 11,000 documents, you have to figure out the redactions, and they have to pay you in advance.
Yes, Your Honor.
And why didn't B happen here?
Why didn't they pay in advance? Because there was an issue and the request was initially sent. It went into the records access officer's spam folder.
Why?
The records access officer believed that it was because this was a request that was sent out to multiple different entities, and that's supported by the fact that the request has a typo in it referring to a school, all documents from your school. So it was filtered to the spam folder.
Because isn't the email that he sent it to the one that's on the website that says if you have a public records request, send it here?
Yes, but there's a spam
One
folder.
would hope that that wouldn't go to a spam folder.
You would hope, Your Honor, but as soon as the agency became aware of it, they responded, they provided the response.
And their response was within 10 days of the date they became aware of it?
Yes, Your Honor.
Did their response say it's going to be, when did they say it's 11,000 documents and it's going to cost, oh, actually they didn't. They said, we'll waive the money on this one, right?
Yes, Your Honor, they did.
But then they never finished.
Yes, Your Honor, they never finished because of the serial nature of the requests. That was the first request. There's 4 other requests that are at issue in this case, but the record reflects that there were approximately 12 requests made by Mr. Friedman over the course of a year. And you have to consider that it's not just the request.
So we only have 5 at issue, but there were actually 12.
Yes, Your Honor, and that is reflected on the Record Appendix, Volume 2, page 37. And then you have to consider for these 5 requests, there were 14 appeals of the agency responses. I don't know how many other appeals were going on, but this is a small agency.
How many, yeah. So you, somewhere in the record, somewhere here, you said that there are 10 employees?
I believe there are 15 employees, Your Honor. It's less than 20.
So, and that's in the record somewhere, I'll be able to find it?
Yes, Your Honor. I can provide you with the citation after the argument if that would be helpful.
But is it in the complaint and the exhibits?
It's attached to the exhibits. Yes, Your Honor, I believe so.
The fact that there are 15 employees?
I believe so, Your Honor.
Your second argument is a mootness argument?
Yes, Your Honor.
Can I hear that?
So, Your Honor, for, I want to be specific, for the May request, which is count 2 of the complaint, and for the first April 26, 2022 request, which is one of the 3 requests in count 3 of the complaint, the agency produced all the documents that were in their possession.
He says that's not true.
Your Honor, if you look at the record appendix, volume 1, page 216 to 217 and 225, as well as record appendix volume 2, page 29, that's where the defendants have provided it.
216 is a letter from your client saying that they provided everything.
Yes, Your Honor.
So for purposes of motion to dismiss, why does the judge have to credit everything your client says?
Because, Your Honor, there's no plausible factual allegations here that would suggest that the statement is false. In order to survive a Rule 12b6 motion, Mr. Friedman would have to allege facts not merely consistent with, but which would show an entitlement to relief. He would have to show that there's a reason to believe that these government employees are lying when they say they've produced the documents or they're incorrect. And we know from various cases that government employees are presumed to be acting in good faith and that there is a strong presumption that public officials do act in good faith. One such case is the Nantastic.
So Mr. Friedman has just represented to us that he knows that there's a document that he hasn't received that was a text message, right? That's number 2. Did he say that and support that in opposition to the motion to dismiss?
I would have to look back, Your Honor, but he did not say that in the complaint.
Right, but did he say that and support that in opposition to the motion to dismiss? You say, I don't know.
I'm not sure, Your Honor, but even if he did, such a statement is entirely conclusory, and it goes
Well, no,
against...
not if he supported it.
Well,
here's a document. I never received this. Look, they couldn't possibly have produced everything because I've got something they didn't produce.
Well, let me be clear, Your Honor. No facts were submitted with the opposition that would substantiate such a conclusory allegation. So, Your Honors, I don't want to belabor going through all the different counts. We do think the court below applied the reasonableness that the SJC has ascribed to the public records law in the Globe newspaper case. We don't think these records were reasonably described, and we think that...
What else is unreasonable, to get at what Judge Walsh was asking you? What else is unreasonable besides the magnitude of certain of the requests?
Certainly, Your Honor. So for count 1, it's primarily the magnitude. For
Okay.
count 2, which was text messages between the BSEA and anyone who worked at the law firm currently or in the past, the agency can't search for text messages with unnamed employees of a law firm. The requester doesn't identify any...
How did you respond to it then?
The agency repeatedly said, we can't do this. That's on Record Appendix 1, 194.
You actually produced some documents.
And
How did you
then-
figure out which documents to produce?
Yes, Your Honor. They went to their agency employees and asked them to search their text messages to see if there were any. So they did the best they could, given the vagueness of the request.
Now, what about the problem that is being raised that folks are using the wrong phones to have company business, if you will?
None of that is in the complaint, Your Honor, and none of that is relevant to the public records request, because this is not a case where we're balancing the public interest versus the private interest.
But when I was working in state government, I had 2 phones. And I was told, fact, I was in charge of telling people, you don't use that phone if it's public business. Use that one.
Certainly, Your Honor, but that's not what Mr. Friedman is alleging here.
Well, that's exactly what he just said when he stood up.
But Your Honor, that's not what he's alleged in the complaint and which the judge considered below. He has just said that there's a failure to respond. He is adding theories after the fact, which you can't do on a motion to dismiss. But continuing through the counts, Your Honor, for count 3, he requested any and all data. I see I've gone over. May I continue going through the counts?
Just to make it clear, Mr. Freeman went 6 minutes over, so you can go a little bit over, too.
Okay, Your Honor, I'll just continue going through the counts to address Justice Englander's question about the reasonable description.
Was wrong, yeah.
Yes. So count 3 sought any and all data contained in the case management system used by the BSEA for administration of hearing requests. And as the agency responded, all data used by the BSEA is used for the administration of hearing requests. It's impossible to respond to this request. In an effort to respond, the agency will provide the hearing request log for the period commencing at the end of fiscal year 2016, and then there's several dates. That's at Record Appendix, Volume 2, page 47. For the second April 26, 2022 request, Mr. Friedman requested for the time period from January 1st, 2000.
This is the log, right? And this is the log of the director?
The calendar.
Yeah, calendar of the director. So I thought I saw even you admitted that it turns out that that calendar gets populated automatically sometimes. Have you provided those?
No, Your Honor.
Why not?
As the agency explained, they have to get special technology to access the data that's in the Exchange server of the electronic calendar. So they have to work with their IT provider to get that information, and that has taken time. The agency continued to be willing to do that and to update Mr. Friedman until the Superior Court made the ruling below.
So they can't even get a calendar that exists because of a claim that, oh, no, we've got to go through 10 more. I'm not blaming you. It brings me to your third argument, which is really about a trial court judge's inherent authority to kind of manage the caseload, for lack of a better word. So for those who had been in the trial court before, and I'm not speaking about you, sir, but there would be individuals who come before the court all the time. And there would be harm if they were filing, for example, a harassment prevention order. That was baseless, right? And so there was at least implicit authority of the judge to say, before that gets a complaint, before something happens, somebody needs to review it to make sure this is good. So this is not an abuse of the process. Your third argument, though, the timing of it is a little bit troublesome. So in other words, you've got a public records request. You've got what appears to be on its face a violation of the public records request. And it seems to me that tell me why a judge has kind of the authority to end run this and say, we're going to put this one on the trash can. We're going to start all the way from the beginning, and everybody's going to agree to the playing rules and all the rest because implicitly, this is a person who's a frequent flyer, right? That's your argument.
Yes, Your Honor.
Okay.
I would say the authority is the same as that referenced in the beginning of your question, which is that to manage the caseload, but also to protect the agency from harassing behavior. The public records law includes descriptions of how the supervisor of records can consider if there is a request or series of requests that are frivolous or harassing, that can be taken into account. And so while that specific provision refers to the supervisor, we do think it's appropriate for the Superior Court here to take that theme, if you will, of harassment and repeated requests and apply it here, where the agency has received over 12 public records requests from the requester in the course of a year. He has made over 14 appeals of the agency's responses, and he is also engaged in other lawsuits against other agencies, as he mentioned, and we listed those for the court to consider below to take judicial notice of. I believe he's involved in at least 4 other lawsuits
Yeah, but,
against
you know,
agencies.
that's saying, so to use the word that was used, frequent flyer, there's an implication that the number means that the person is engaged in frivolous behavior. Some of these requests just are not frivolous. They're not, okay? I mean, and you can respond to them. Even the first request, okay, $11,000, he should have to pay for that, all right? I used to sit on the other side of this. He should have to pay for that, but you've said you don't have to pay for it, so that's water on the, but it's a request that you can identify and figure out what they're asking for. It's hard because you're going to have to redact, and you're going to probably have to send it out to somebody to do it. But it's not frivolous.
Well, Your Honor, every time the agency has responded, including when the agency produced the first batch of documents to that first request, Mr. Friedman has appealed to the supervisor and said, actually, you should have produced them in this format. Actually, you should have done X, Y, and Z. He continues to raise issues, and instead of communicating
The
with
supervisor's job is to say, no, you're wrong.
Yes, Your Honor, but the agency can't go through 11,000 documents.
By the way, when you're up here, I'm sorry to do this to you, but been through this process. Where is the supervisor? Are you representing the supervisor's interests?
No, Your Honor,
Who would do that?
If the supervisor of public records, the public records law allows for certiorari review of a supervisor's decision. So you could have a certiorari
Right, but
review.
it seems to me the supervisor they got an interest here. Do they even get notice? When he files a complaint, the Attorney General now represents the agency. Does the supervisor even get notice that the complaint's out there?
Not formally, Your Honor, I don't believe. There are 2 separate mechanisms for relief under the law. You can go to the supervisor, you can go to the courts, and the SJC has recognized that the deference afforded to the supervisor's decisions is minimal. That's in the Globe newspaper case.
I think we're going to have to leave it at that.
Thank you very much, Your Honors.
All right. Well, that concludes our sitting. I would like to thank all the attorneys, even though they've all left, except for one, that were here today. I'd like to thank our court officer. I'd like to thank our clerk's office. I'd like to thank our timekeeper. It was her first time as timekeeper, and she did an excellent job. And with all that said, we will stand adjourned until tomorrow at 10 a.m. in the Kemper Auditorium at Phillips Andover Academy. The next sitting in this courthouse is Wednesday at 9:30. Thank you.